Good afternoon, everyone. This is Tuesday, February 1st. How should you yourselves mute and only unmute when you are recognized to ask a question? After a witness testifies, you may ask questions by selecting the raise hand feature on your Zoom, and I'll recognize people in the order in which they raise their hands. Witnesses, you will unmute yourselves when I recognize you to present your testimony. After you present your testimony and answer any questions, please exit the Zoom hearing room. At all times, members of the public will be able to view the live and one for the witnesses. Those are House Bills 278 and 67. The order today is going to be House Bill 278 from Delegate Davis, House Bill 67 from Delegate Lewis, House Bill 25 from Delegate Ampry, House Bill 249 from my House Bill 122 from Delegate and this is House Bill 278. We have 6 signed up favorable and 4 signed up to testify favorable orally. So we can. I'm going to move my computer. I'm breaking up. That's a quick view of my house. So sorry, we have 4 people signed up to testify favorable on House Bill 278 and no one in opposition. So we will go ahead and start with Delegate Davis when you're ready.
Thank you, Mr. Chair. Colleagues, for the record, I'm Deborah Davis presenting HB 278. In short, it's a bill on inmate cost of living report. That's the title. The Maryland Correctional Enterprise is a multi-million dollar enterprise in the state of Maryland. And I believe as policymakers, it's incumbent upon us to know what is happening behind the walls and how our tax dollars are spent. The bill is the same as it was last year and the year before, and I'm happy to say that we passed it out of the House without opposition, out of our committee without opposition in 2020 and 2021, and it died in JPR. I'm respectfully requesting a favorable report. Thank you.
Okay, let's see, we have Linda Moyd and Olivia Spacassi. It looks like Kimberly Haven is not in the waiting room. So let's go ahead and get started with Olinda Moyd. You have 1 minute.
Good afternoon, everyone. My name is Olinda Moyd. I am a prisoner's rights attorney and a resident of Prince George's County. So I bring you greetings from, today I'm speaking on behalf of the Maryland Alliance for Justice Reform. So I bring you greetings from our organization. We are a nonpartisan, diverse group of individuals who represent a broad range of Maryland residents who care about what happens to the men and women who are behind bars. I chair the Behind the Walls work group, and we receive correspondence on a daily basis from men and women who are in our jails and prisons. We support this bill for several reasons, primarily because it shines a spotlight on the hidden costs that's associated with incarceration in Maryland's institutions. Poor families and disproportionately Black families often struggle to put money on the books or add money to commissary for their loved ones so that they can buy necessary items. Women need feminine products.
Your time's about up.
Okay, and Major receives letters from women complaining about not having enough funds to take care of themselves. This is just representative of one of the challenges that they face. And we ask that you read my written testimony and provide a favorable report. Thank you.
Thank you. Next, we'll have Olivia Spacassi.
Good afternoon, everyone, members of the committee. My name is Olivia Spacassi. I am the public policy intern for the ACLU of Maryland. The ACLU of Maryland urges a favorable report on HB 278. As of 2019, Maryland corrections workers earn between 17 cents and 1.16 per hour. These extremely low wages indicate a deficit in affordability for paying for basic necessities, the prices of which are increased by up to 350% in correctional facilities. A lack of data and overall transparency about the cost of living in Maryland's correctional facilities means that policymakers and administrators cannot fully understand or address predatory pricing for basic necessities. Studies show that adjusting prices to be more reasonable will still provide a profit without creating such a damaging financial burden for people within the criminal legal system and their families. For the foregoing reasons, the ACLU of Maryland urges a favorable report on HB 278. Thank you.
Thank you. It looks like Kimberly Haven made it and is next. You have 1 minute.
Thank you so much. I'm here on behalf of Forward Justice Maryland in support of House Bill 278. I'm not going to repeat what we all know this bill is about. It's a reporting bill, but it is a critical reporting bill. I say often that we can't address what we can't see, and we can't see what they don't tell us. DPSCS has an enormous mandate, no argument, but they are also a giant black hole. They're a significant part of all of our budgets, state and local, yet there is no measurement for how they do and what they do to meet their mandate. For years, advocates have been trying to get information from the department. I have appeared before this committee on several occasions about the issues about pay scales and the costs individuals have to bear. This legislation will expand the annual report the DPSCS already issues. This legislation also requires that they report out on new things that we've been trying to get that information. Again, we can't address what we can't see. We can't see what they don't show. This is good legislation, and we urge a favorable report on House Bill 278. Thank you very much. Did I meet my time, Delegate Moon?
Well done. I believe that is all of the witnesses signed up to testify in this bill. Are there any questions for the sponsor or this panel? All right, I see Delegate Nokomis's hand up. Go ahead.
Thank you, Mr. Chair. I appreciate it. I wondered if Chairman Moon, Vice Chairman Moon, if you could maybe share the letter that we got from the Correctional Services or the Department of Corrections or Public Safety, because they kind of said what they were doing now. And I think it would be good if the advocates could at least look at it and see where everybody is. The thing I'm most concerned about is the issue of the commissary expenses. I know that, and so it would be very interesting to know what the prices were for the different commissaries in the different institutions, because I know that public safety is a concern, and the issue of let's say, sneaking bad things in there one way or another. I mean, I've heard all kinds of crazy stories. So you want to make sure that these products are coming from a reputable source. But I do have a real serious problem if you can get the same amount of product at Kmart for $2 and they're charging you 17, which was related in some of the testimony. I mean, I guess because I'm kind of Scotch and kind of conservative when it comes to spending money, I just find that horribly offensive. So I think that, and I know that it would put a strain on the family, but I do know that the department is also giving them, they said 5 calls within a week, and they can be 15 minutes each. So it would be nice to know where's the truth. And because they're not here to hear your testimony, and I don't know if they've had an opportunity to read your written testimony, it just would be nice to kind of see if we're kind of all if we can get all on the same page. That would be great. The other comment I have, and maybe, is that I know some of you use national statistics regarding some of these issues. And I think we need to kind of focus on what's Maryland. And so that, you know, I know you get statistics where they count, but that's something that would be helpful if you could maybe limit it to Maryland, or get, you know, go back and look at the written testimony and see if you can find what you're talking about and not use national, but use Maryland. Thank you all very much. And I know that you have a lot of information and you're only given a couple minutes, less than a minute, maybe. Thank you.
Ms. Haven, it looks like you have your hand up to respond to that.
Yes, I just wanted to respond very briefly. There is a big disparity between what is charged on the street and what is charged behind the fence. There is also a very big discrepancy, maybe not as much or as glaring, but between the facilities. So MCIW pays higher for some things than some of the men do. And we know this because we share information. And so it would be great. And I think that to your point, Senator, Delegate, sorry, is that if we had what Maryland would report out on, then we would be able to assess, we would be able to look at, we would be able to, okay, in my case, argue for what they're doing to meet the mandate. But it does pose a significant burden on families and individuals, particularly when we don't know what those prevailing wages are that people are earning. And it does put a significant barrier. And those 15-minute calls have been great during COVID, but we have no assurances that once we get past this pandemic, please, Jesus, let's get there soon, that we're going to go back to the old way and those phone calls disappear. Thank you, Vice Chair Moon.
Thanks. Are there any other questions for the sponsor of this panel? Okay, I believe that ends the hearing on House Bill 278. And we will now, is Delegate Lewis?
Yeah.
Okay, great. So we're going to now go to House Bill 67 from Delegate Lewis. This is another reintroduction on the 2 minute for sponsor, 1 minute for witnesses schedule. And we have 6 people signed up to testify on this bill. So why don't we, as they're coming in, go ahead and get started with Delegate Lewis.
Thank you, Chairman, and members of the Judiciary Committee, my home away from home. I thank you for your time and consideration of this bill. This bill is the step down bill. I brought it back again in different forms. This bill will provide a step down program to prepare the incarcerated for the transition from restrictive housing to the general population or community. Furthermore, this bill would allow former inmates to seek civil damages if they suffered a specific or direct injury from being denied the right to access a step-down program. So why does this matter? Restrictive housing, as you all recall, is the involuntary placement of someone in a cell, either by themselves or with another person, for 22 hours or more per day. Studies have shown that it has been linked to many negative psychological and physical behavioral problems, including anxiety, depression, irritability, paranoia, disturbed sleep, cognitive impairments, social withdrawal, cardiovascular disease, impaired vision, self-harm, and even suicide. Releasing these individuals directly back into the population without a transition program limits the chance of successful reentry into the community, posing a potential public safety risk. Successful reentry to the general population ensures that released inmates do not reoffend. One study found that without meaningful programming, individuals released from restrictive housing are at a higher risk to return to criminal behavior, returning them back to the prison system. Given the current COVID-19 pandemic, decreasing prison populations is more important than ever as they are hotspots for the virus. Maryland's prison system received a D- on its response to COVID-19 when they would fail to reduce the prison population by more than 2%. A transitional program would help decrease the recidivism rate and continue to decrease our prison populations in a responsible and safe way. Maryland's Department of Corrections often claims that this program is not needed because they already do it. Well, if you already do it, then it is redundant for us to put into statute to say that you should do it because it's already being done. They will likely follow behind me and also say that this program costs too much money, which is also reductive because if you're already doing it, then it shouldn't cost you much money. For all the reasons I've already stated, I urge a favorable vote on this bill, and I appreciate your consideration.
All right, thank you. And we have actually 4 or 5 witnesses signed up in this order: Kimberly Haven, Rachel Kamens, Debbie Ramsey, who might not be in the waiting room, Olinda Moyd, and Mooney Larosby, and we'll go in that order. If we have, and this is a 1 minute, folks, so if we have Kimberly Haven, you can go ahead.
Thank you so much, Mr. Vice Chair, members of the committee. I am here before you again on this issue that you are well acquainted with. When we first brought this issue to the General Assembly, there were 4 groups that the members found problematic: youth, pregnant women, serious mental illness, and direct release. We are here now to close that loop, to address the concerns that were raised by this legislature. I have seen the informational bulletin that the department has submitted, and we will be submitting refuting testimony to that. But at the end of the day, this is a bill that if they're already doing it, there is not a fiscal note. This can be managed with existing resources. This is good public safety. This is good policy. This is the year to pass this bill and make Maryland a leader in how we do reentry and how we don't abuse, and don't overuse solitary confinement or restrictive housing. Again, picture yourself in a room with somebody you don't know in a space that's as big as a parking space, and figure out what that would be like. And that's what we have to end. That's what we have to step down so that people can reintegrate back into our communities safely. They can have a transitional system. They can have a support system. They can do this safely. If we're true about reentry, if we're true about rehabilitation, then this legislation must pass this year. I urge a favorable report on behalf of the Interfaith Action for Human Rights on HB 67, and I thank you for your time.
Thank you. Next, we'll go to Rachel Kamens.
Good afternoon, Mr. Vice Chairman and members of the committee. My name is Rachel Kamens, and I'm here on behalf of the Public Defender in support of House Bill 67. Individuals held in restrictive housing have little to no social interaction, access to education or programming, physical activity, or communication with loved ones, much less preparation for entry into the general population or direct release into our communities. Let's keep in mind that restrictive housing includes administrative segregation, where the inmate has done nothing wrong and is often kept there for his own safety, as well as disciplinary segregation. The step-down process provided for in House Bill 67 will position returning citizens, an estimated 4,000 per year, for successful integration into a world that is vastly different from when they left and is ever-changing. This bill will have a direct impact on public safety. Data shows that states implementing such step-down programs enjoy reduced recidivism, which clearly benefits society at large. The Public Defender urges the committee to issue a favorable report on House Bill 67. Thank you.
All right, thank you. I think we're next going to go to Olinda Moyd.
Hello again. I am Olinda Moyd, representing the Maryland Alliance for Justice Reform, and we support a favorable report on this bill for several reasons. We do know that solitary confinement or restrictive housing is overused in our institutions. It's overused if someone is deemed a problem inmate, quote unquote. And so it is important that, for all of the reasons stated by Ms. Haven, that individuals have an opportunity to have step-down services available to them before they are reintegrated into the prison population and certainly into the community. The bill calls for step-down services that include increased out-of-cell time, increased group interaction, increased education and programming. So all of those things are essential for an individual to successfully re-enter the community and be successful. For those reasons, including the information that has been submitted in my written testimony, the Maryland Alliance for Justice Reform supports this bill.
Thank you. Now we will go to Munib Lorosby.
Thank you, Mr. Vice Chair. For the record, my name is Munib Lorosby, here to provide testimony on behalf of Disability Rights Maryland, Maryland's designated protection and advocacy agency. I wanted to start with the point that restrictive housing is a harmful practice. It exacerbates existing symptoms of mental illness and can lead to mental illness in individuals who are undiagnosed. When we're in prisons talking to folks who are living through these conditions day to day, the most requested thing that we hear is socialization services, including transitional services, of course. For traditional purposes, yes, like applying for benefits, housing, getting a job, but also just for reorientation to society. Folks want to be able to talk to their kids, talk to their families in ways that they simply haven't been prepared for. And that is backed when you note that there are higher recidivism rates for individuals who are released to the community without transitional services. So for these reasons and for everything everyone else is saying, DRM urges this committee to support the legislation before you with amendments that will prevent the department from keeping folks in restrictive housing longer than they would otherwise.
Thank you. And I don't believe Debbie Ramsey is with us. So that looks like all of the testimony on this. Are there any questions for this sponsor or panel? I see Delegate Cox's hand. Delegate Cox, go ahead.
Thank you, Mr. Chair. And Delegate Lewis, it's good to see you, sir. Welcome back. I have just some clarity questions. It's my understanding, I just read the bill and looked over the finance report. Now, it looks to me like everything in your bill appears to be already mandated, but apparently, and I know this from the tour of the prison that we took as a committee, that some of these things are just not happening. Is that a fair assessment? In other words, the intent of your bill is to just try to do what's already mandated in law. It's not really providing additional rights. Is that fair, or there's something I'm missing? Is there something additional that's not already supposed to be done?
The cause of action is additional because, to your point, it isn't currently happening. And you hit it right on the nail, Delegate. Folks tell us that they're not getting these services. So we just want to make sure they actually get it.
So I'm looking at your bill and I don't see a cause of action. I see that they have to provide this transition so that you don't just drop people in the street like in Hagerstown. I know that's a problem in my district and in the area here where I'm serving. And I think the last time I talked to one of the program assistants, they said they're having trouble finding the proper teams, psychologists, psychiatrists to help do this work. Have you heard whether or not the state will be able to actually find practitioners that can do this, since they already seem to have some issues with that?
Sorry, I'll let you finish your thought, Delegate.
No, and then the other thing is, where is the cause of action? I don't see that. I mean, I'm probably missing it.
Yeah, so it's on the last page, section G. A former inmate who has suffered a specific and direct injury from a denial of the right to access a step-down program under this section may bring a civil action in a court of competent jurisdiction for damages, including costs and reasonable attorney fees. So that's the last section of the bill on page 3. I think across state government, there has been challenges with us getting our staffing up. I also think that we have a duty to these citizens to make sure they get the services that they are entitled. That is our responsibility, our pledge to them, and we need to get the job done. So that's why we're bringing the bill. I will also note that this bill has passed this committee in the past. So this isn't, as you know, a new thought. It's just trying to make sure we get the job done.
And lastly, Mr. Chair, if I can just one more, I noticed that there is a savings clause that says if there's a determination an inmate has presents a grave risk of harm, that they shall be denied this. And that similarly seems to comply with state law that inmates that are continued risks obviously do not qualify for the diminution credits, et cetera, correct?
100%. It's, I mean, you know, we want to make sure that folks get the access that they are,
Okay.
you know, that they're entitled to. One of the things that we recognize, though, is that in order to connect the currently incarcerated to those services, you know, our current correctional officers will have to go get them and bring them and whatnot. It's not safe to do so for our officers or for other people. Then obviously we don't want to put them in danger, but we don't want it to be a carte blanche that they don't get services because either for administrative or disciplinary reasons, they've been placed in segregation and then they're not able to get what they need to return to society healthfully.
Thanks so much. Good to see you again.
Always a pleasure.
All right, let's go to Delegate Shoemaker next.
Thank you, Mr. Chair. Far be it from me to be concerned about full employment acts for lawyers, you know, as a general rule. But yeah, that's kind of what this is, I guess. So who would be the defendant, I guess, in one of those causes of action that you referred to earlier, Delegate Lewis? I get, would it be the DOC or the Department of Public Safety or whoever it is?
My understanding is that it would be the department, and I definitely added that for my favorite country lawyer. I anticipated a question from my good old favorite country lawyer.
I appreciate that. And of course, you would agree with me that in suits brought against the Department of Public Safety or Division of Corrections, whichever defendant it is, I mean, the taxpayers are going to be ultimately responsible for footing the bill for those awards of damages. Is that right?
Yeah, I am well aware, Delegate. I'm also well aware that we paid $45,000 annually to house every person who's incarcerated in the state, and hopefully through us making sure they get these transitory services, they're able to be reconnected to their families and society, that they won't recidivate and then cost the state even more money.
Thank you, sir. Thank you. I appreciate it.
All right, we've got Delegate Cox's hand up for a second bite.
Real quick, Mr. Chair. So along the lines of my favorite country lawyers questioning, Delegate, would you be open to changing this from damages to simply a civil injunction? In other words, so that if it's not happening, rather than going straight for damages, you could get just a court order that says that, you know, they have to comply?
I am always more than happy to talk to my colleagues offline about potential changes, but you know, we can have a conversation offline about that. Thank you, Delegate.
All right, we've got Delegate McComas's hand up.
Thank you, Mr. Chair. I'll make this brief, Delegate Lewis, but we got a letter from the public safety, you know, saying that they didn't want to be, they didn't want this, I guess, enshrined in a statute, because if the conditions change, they wouldn't be able to be as nimble. They would have to wait till the legislature could make the changes. And then they said that one of the reasons is they're looking for accreditation of their practices, best practices for the different institutions. And they were saying, they were comparing Maryland recidivism rate to Virginia. And I don't know if Virginia's accredited, but it would be great if you could get a copy of that letter if you did not receive it, because I'm kind of interested to see if that issue is a problem or not, if we memorialize this in litigation. And I'm surprised they didn't show up, but it was like one of these letters of information and they kind of went through it. And so I'd like to get your thoughts on it, you know, when you have a chance to look at it and you could get back with us.
Sure thing. Very quick response. First, I have a really good relationship with the department. I actually think Secretary Green is doing a yeoman's job under very difficult circumstances. I didn't get their letter, but I will, just as a brief history lesson, let folks know Secretary Green worked on the national accreditation standards, and the department has been working on getting accredited, I believe, for about 4 or 5 years now, with the standards that he helped put together. In past legislation, we brought forward language to just institutionalize the accreditation standards that they say that they want to hold themselves to. I think just generally in government, it is good for us to have accountability measures in place to make sure that we do the things we promise the public we are going to do, which is why I continue to bring back this bill to make sure folks get the services that ultimately is not only good for them, but is good for the public, right? Which is who we aim to serve. So I'll look for that letter, but I don't think we should hold off for accreditation standards when they have been saying they're going to try to get us in line with accreditation for going on close to 5 years now.
Thank you.
All right, it looks like we have a very quick response from Kimberly Haven and Munib Larosby, and we will, it looks like we'll close the hearing on that.
Thank you so much, Mr. Vice Chair. To the delegate's point, the accreditation, this issue is not something that is stopping the accreditation. There are multiple issues that the department is working very hard on to try to address. This is an issue, in fact, you supported this issue in the past. This is just bringing it home. When the letter, and I do have a copy of the letter, at the bottom of the letter, when they said they want to be nimble, we support the department being nimble and agile. But honestly, they're trying to institute best practices. They're not there yet. This would put the best practices in place. And when things evolve, when things change and they want to be nimble and respond, that's great. We will support that as well, because honestly, the next iteration of this issue will be to completely get rid of restrictive housing. So, we support the department. We know they're doing an incredible job. This just works to prevent people coming home without supportive services that endangers our communities. It also gives an opportunity for resocialization back, because this is how we treat people. We treat people with dignity. This is a bill that is rooted in dignity and a belief in reentry. Thank you so much, Mr. Vice Chair.
And I'll be even quicker, Mr. Vice Chair. Just addressing the questions that Delegates Shoemaker and Cox had about the private right of action that's created by the bill. To my knowledge, the Prison Litigation Reform Act would still apply, requiring incarcerated individuals to exhaust all administrative remedies before they're eligible to file a lawsuit in an Article 3 court. So those sort of procedural barriers to make sure that these are substantive matters are already built in and do apply to this.
All right, thank you, everybody. That's going to conclude the hearing on House Bill 67. We are now going to go to House Bill 25 from Delegate Amprey. It looks like he's here. And there are 7 people signed up to testify on this. It looks like all favorable with one or two favorable with amendments. So let's go ahead and get started with Delegate Amprey. This bill is on the 3-minute, 2-minute rule, 3-minute for the sponsor, and 2 for the witnesses. Delegate Amprey, whenever you're ready.
Thank you so much, Mr. Chair and members of the Judiciary Committee. It is a pleasure to be in front of you today. Today, I will be testifying in support of House Bill 25, the Rehabilitation and Education for All Prisons Act, also known as the REAP Act. And this bill is something near and dear to my heart as a individual who has seen the prison system not work for many people and families. Me personally, watching my father and brother go through the system in which, there was a struggle for them and a struggle for my family. And the purpose of this act is requiring the Department of Public Safety and Correctional Services to set certain goals for the number of inmates in rehabilitation programs and establish certain tracking systems that those who are incarcerated will have access to, along with families and others, in order to track their progress, and requiring the State Department of Education and Department of Human Services and other departments that we are still forthcoming to work with. There is amendments coming in order to set up a system in which we have more equity in action. The unfortunate reality is that while we tout certain services that are available to those who are incarcerated, many are not able to access all the services that are there. The goal of this legislation is to ensure that as many services that are available are made available on day one. I think the unfortunate reality is that when we think about reentry and rehabilitation and services before people leave and go into society, we're thinking about it 12 months out, 10 months out, 90 days out, 120 days out. But my philosophy and the philosophy that we should have as a state is that the minute someone is sentenced and they go into those doors, the thought process should be, how are we going to rehabilitate and educate this person so they can be the best person when they reenter society and lower recidivism rates. So our goal here is to create a better metric and system and standard of care for those who are incarcerated so we can measure and track those who are falling through the cracks, and also to ensure that families, future employers, judges, probation hearing officers can see the actual progress of individuals who are incarcerated. And it goes beyond just tracking their behavior in prison, but more so thinking about what books have they checked out and read, what programs have they completed. I know many prisoners today now have access to tablets. What therapies have they gone through? All this information is often happen to be tracked by the individual themselves. On their own when they go before a judge or before a probation hearing. If we're able to track this for them and so that they can see the progress, is a way that we can ensure that equity is being put forward, and that whenever they go in front of someone, nothing is forgotten when there are opportunities for them to expand upon pre-release. And just to give more detail as to why we have to do more as a state, I represent District 40 here in primarily West Baltimore. And the unfortunate reality is that we have the highest number of individuals that are going into our prison system, which also means that we have the highest numbers that are going to that lead into recidivism. Currently in Maryland, we have a recidivism rate of about 40%, which ranks at the top 25% in the state. We can't have a state that has some of the best education in the state and then also have the highest recidivism rates. We've got to have more of a all hands on deck approach to how we are assisting those who are incarcerated and ensuring that everyone has access to opportunity. And I want to leave with this, with thinking about this also as a public safety issue outside of an equity issue. The unfortunate uptick in violence that has occurred in Baltimore has really hurt our city. But the reality is that almost 65% of those who were victims of gun violence or those who perpetuated the gun violence were under the state supervision in some form or fashion. And what that tells me and what it tells us is that we have to do more at the state level to provide as many resources as possible for those who are incarcerated and ensure that we are giving them every opportunity to succeed upon their entrance into our facilities. And I had an opportunity to tour many of the facilities this summer and speak with the Department of Corrections. They are working their hardest to get things done, but we need more partners at the table. So the focus and goal of this bill is to get more partners at the table to ensure that we are creating the most elaborate systems available to ensure that we are giving people their opportunity to have access to opportunities. And to track those opportunities. So I hope for a favorable report on House Bill 25. And again, there are some amendments forthcoming that we will make available to the committee as soon as possible.
Great. So we're going to go and have Aman Sika first, and then Elise Desiderio. I don't think we have Nicole Hansen or Earl Young here. If we get them, we'll add them. So next, we'll go to Kimberly Haven and then Brad Phillips. So let's go ahead and start with Aman Sika from Winston Churchill High School Democrats. Might not be in the room. If not, do we have Elise Desiderio? Okay. Let's go to Kimberly Haven.
Hi again. Good afternoon. You know who I am. I'm here from prison cells to PhD. We're here with favorable with amendments. This bill additionally puts a heavy lift on DPSCS as it relates to accessing federal Pell Grants. We have been a leader in higher education in prisons. We have worked with, prior to COVID, actually very well with the department. We have consulted with the National Department of Education and the Pell, I'm sorry, the clock is killing me, y'all. On Pell implementation and training. We are actively working on developing those training materials for state legislators, departments of corrections, and universities. We believe that from prison cells to PhD is an integral part of this process. Additionally, we are concerned at what appears to be a small subset of institutions of higher education. We would like the opportunity to work further with the bill sponsor, who we have reached out to develop a sound, progressive, well-informed, and achievable legislation. For that reason, we offer a favorable with amendments on HB 25. Thank you very much.
Thank you. Now we will go to Elise Desiderio.
Good afternoon, Mr. Vice Chair and members of the committee. My name is Elise Desiderio, resident of Baltimore City and Assistant Public Defender. The Public Defender's Office urges a favorable report on House Bill 25. We know from our representation of incarcerated clients that our clients are interested in and many eligible for reentry programming, but access is a huge problem. Wait lists are months or years long, even before the COVID-19 pandemic. Moreover, we know from hearings for motions for modification, we know from parole consideration hearings and other similar matters that judges and commissioners place particular emphasis on successful programming participation. And this emphasis, paired with the difficulty of access that our clients face, means that clients who are stuck on a waiting list are placed at a significant disadvantage at these hearings through no fault of their own. Moreover, we know that returning citizens deserve and require support when they re-enter our communities, especially considering folks serving decades-long sentences where the community that they return to is very different from the one that they left. Technology, infrastructure, job market, housing market, all of these things can be vastly, vastly different. And reentry programming that includes things like anger management, job readiness, 12-step programming, working, all kinds of things that really do help our clients as they re-enter our communities. We really need a bill like this to hold ourselves more accountable and make sure that we are walking the walk with what our clients need and deserve. Maryland's recidivism rate is around 40%. Virginia's recidivism rate is the lowest in the country at 23.4%. And they credit their robust programming for that low recidivism rate. And we know that, finally, we know that rehabilitation is a stated policy goal of incarceration. And this bill would help our state meet that goal. And for those reasons, the Office of the Public Defender urges a favorable report on House Bill 25. Thank you for your time.
Thank you. Next, we are going to go to Brad Phillips.
Good afternoon, Mr. Chairman and members of the committee. My name is Brad Phillips, and I'm here representing Maryland's Association of Community Colleges and all 16 community colleges in Maryland. It's not often we get to meet in front of this committee, so I'm glad today to be here to talk about what we do currently as a segment for incarcerated individuals in prisons. We've been offering educational opportunities for inmates for decades, and it has proven to be successful for reentry once students actually earn some type of credential. And I think that's why we're here today. We just want to make sure that we're included in advising the Department of Public Safety and Correctional Services on accessing Pell Grants and other issues regarding going back or earning a credential. You know, it's four-year degrees are one thing, but what's really made a big difference in a lot of individuals' lives is being able to take something that's more of a short-term certificate or a licensure program. We offer, for example, adult basic education training, business officer management, construction math, financial literacy, employment readiness workshops for inmates that have all really helped for reentry. And we're just here to basically say we'd like to also be a part of that. And we have 3 colleges that have participated with Second Chance Pell, and we're hoping that we can get those included as well. And I believe Delegate Ampry is open to that, and I've heard that conversation already in testimony. So those colleges would be Anne Arundel Community College, Hagerstown Community College, and Warwick Community College, who all work with their prison populations. And with that, we just urge a favorable report, and thank you so much for your time.
Great. That looks like that's the end of the testimony that signed up and is here. Are there any questions for the sponsor or the witnesses? No questions. Okay. I believe that ends the hearing on House Bill 25. Thank you. All right. I think I'm up next. House Bill 249, a little awkward. This is a new bill, so I'll give myself 3 minutes and 2 for the witnesses. There are 7 people signed up on this bill with a mix of opinions. So we'll start with the sponsor, me, and the favorable panel. So Dylan, you can clock me. I'm going to go ahead and start myself. So colleagues, House Bill 249, number 1, it comes with an amendment, so please take a look at your floor system. But in short, this bill asks that when taxpayers pay money to someone because they were wrongfully imprisoned when they were innocent, that we simply notify the professional boards of the lawyers, judges, and police who were involved in that case and send them the basic case files. They can choose to do nothing with that information, but it is my hope that they'd at least read it to see what went wrong. So by way of background, 20 years ago in law school, I was investigating cases for the Mid-Atlantic Innocence Project. And back then it was known that official misconduct was a contributing factor in at least half of wrongful convictions. But 20 years later, I have to say, it's been slightly devastating to see that our professional governing bodies appear to be ambivalent about the existence of these cases. I would argue that in law and in criminal justice, imprisoning innocent people is a catastrophe. It's the professional equivalent of a doctor amputating the wrong leg. But from the bills that we recently passed that you're aware of, right now what we do is we pay the defendants money, and these are extraordinary cases, right? There aren't that many of them, a few dozen. We pay them money now. Taxpayers are shelling out millions of dollars in these cases. We say oops, and then we move along. So the bill is introduced, called for an investigation of the police, judges, and prosecutors and defense attorneys in these cases. We had to change it because, as you can imagine, the judges didn't like being told that they had to investigate. Likewise, neither did the police or prosecutors. And that's why in the amended form, all we're doing is forwarding notification that one of these catastrophic incidents happened and hope that they will take action. So I'm a lawyer. I went to law school. I know some of you are too. We work in an adversarial system, but we have rules of professional conduct. And their Innocence Project is going to come talk about some of these cases, in particular in Maryland, and they've been in many counties. They're a range. Some of them there was errors, some of them maybe just a bad lawyer, and some of them had intentional misconduct. I'm unaware of any of the professional disciplinary bodies having taken it upon themselves to look at this, and they will tell you that's not how it works. Someone needs to refer the matter. So the bill as amended, again, would call for the AGs who have a PIN in their office to deal with these wrongful conviction cases now to simply forward those documents. There ought to therefore be no fiscal note on this. And again, I hope that we can all come to the table and find a solution. In private conversations with all the parties, I warned them this bill was coming. Everyone has acknowledged that there's a problem. and that nothing happens with the information in these cases. Sometimes the misconduct is on the official record, but something must be done. And yet they're not stepping forward to provide that solution. So I'm here to do that today. And with that, I will shut up and turn it over to the next person testifying, which will be Sean Ambers for the Mid-Atlantic Innocence Project. And we've got Nathaniel Erb from the National Innocence Project.
Thank you so much, Delegate Moon. I'm Sean Armbrust, the Executive Director of the Mid-Atlantic Innocence Project, which works to prevent and correct the conviction of innocent people in Maryland, Virginia, and DC. And I'm here to urge a favorable report on House Bill 249 as you've amended it. My colleague is going to testify about this more, but Maryland has higher than average rates of official misconduct in its exoneration cases. Of the 25 most populous states in the US, only Illinois and Missouri have higher rates of official misconduct and exoneration cases. And unfortunately, there's really no accountability for those actions. And there's no effort to learn from those mistakes that taxpayers and innocent people are paying for with their lives and with dollars. I want to talk a little bit about what that looks like on the ground. Just give you guys some examples of some of that misconduct for which there is no accountability as it exists right now in Maryland. In one of our cases, police secretly recorded a conversation with the state's key witness in which she was promised a specific benefit in exchange for her testimony. The state's attorney himself signed off on the benefit. That wasn't disclosed to the defense. When the witness testified at trial, she said there was no benefit, something the prosecutor knew was a lie, but didn't correct and actually reinforced. And those clients went to prison for something they didn't do based on that lie and that misconduct. In one case that involved a wrongful conviction, police obtained a false confession from an intellectually disabled defendant. They threatened him with the death penalty. They lied to him and told him he'd failed a polygraph test. They fed him details about the crime, and they interrogated him throughout the night without sleep or food. In another case, with two brothers who were wrongfully convicted and each spent 25 years in prison, the case with the conviction itself was based on the testimony of an alleged eyewitness whose account of the crime differed from the statements of other witnesses who were there. She said the crime had occurred in one place. At least 3 other witnesses said it had occurred somewhere else entirely. That information was never turned over to the defense, so they couldn't use it to impeach her. The only other witness was a 13-year-old witness, 4'8", who was brought into the police, testified that our clients were not the assailants, screamed at by the police, coerced into confessing coerced into naming those defendants, attempted to recant on the stand, and was called a brat by the judge and traumatized for much of his life. Nothing has happened to any of those individuals. In the last case I talked about, both the police officer and the prosecutor have been involved in multiple wrongful convictions with no punishment or accountability of any kind. The prosecutor was actually promoted and ended up training other prosecutors. They're all from different jurisdictions in Maryland, and there's nothing to stop that kind of conduct from happening and continuing to happen and cost lives unless we start looking for measures of accountability and unless we start trying to learn from those mistakes. House Bill 249 would be a great starting point, and so I hope you will all support it.
Thank you. Next, we'll go to Nathaniel Erb.
Thank you, Mr. Chair. Good afternoon, members of the committee. My name is Nathaniel Erb. I'm here on behalf of the National Innocence Project and the University of Baltimore Innocence Clinic in support of House Bill 249 as amended. In Maryland, official misconduct has contributed to over 70% of wrongful convictions, and 33% have involved inadequate defense. This accounts for 35 known cases of Marylanders across 6 counties. Every wrongful conviction exacts a tremendous toll. The wrongfully convicted and their families suffer incalculable losses and trauma. Victims and their family do not receive justice and have to relive their trauma. Communities lose valuable members, continue to experience crimes committed by the real perpetrator, and lose already scarce trust in law enforcement. Of the first 375 DNA exonerations nationally, The true perpetrator were subsequently identified in 50% of those cases. These 165 people committed an additional 154 violent crimes while an innocent person took their place in prison. Maryland has taken the first steps in addressing wrongful convictions by creating pathways for the innocent to bring their cases to court, and by taking responsibility for the harms caused through compensation. Maryland should now lead the country in addressing these most egregious causes of wrongful conviction. This will help provide justice for Maryland's exonerees and better protect its citizens. We urge a favorable report with as amended, and thank you for your time.
I believe we have the chair back. Mr. Chair, are you with us?
I am, and I see that we've completed the witnesses in favor of the legislation, I believe. And
Yep,
so I see now there are three delegates who would like to ask questions of that panel, and that's what we'll do. We'll switch to questions to the favorable panel. We'll start with Delegate Arakan, then Delegate Shoemaker, Delegate Cox. Delegate Arakan.
Thank you, Mr. Chair. Welcome back. So Delegate Moon, I'm just looking through the actual language, and I know you mentioned in your opening that you had concerns about, sometimes bad lawyers or whatever. So I see that you did include on page 6, the attorney who represented the defendant in who shall be investigated. But then in section C, you did not include like the bar so there's no mention of that defendant's attorney, having their documentation sent to any sort of regulating body. Is there a reason you excluded that? Why would you?
Yeah, no, so this draft was really a placeholder to get the concept of how to do a mechanism moving. It originally would have called for an investigation and audit of these cases, but after talking with the Attorney General's office, frankly, it was a cost issue first and foremost that would involve resources that they did not currently have. And so after talking to them, I adapted the model to be much more simple. Also, the judges complained that they didn't want to be told to do an investigation themselves. And so all this does is it forwards notice that the taxpayers have paid this money because of an innocent person, and it forwards that notice along with the basic files to the Attorney Grievance Commission. So that would be for both the prosecutors and the defense attorneys. It could be ineffective assistance. It could be a Brady violation and withheld evidence. It could be nothing, and they could decide not to do anything with it if there wasn't anything on the face. Again, these are well-documented cases with court records and things like this. The rules of professional conduct for attorneys actually suggest that we are supposed to report known professional misconduct. I'm unaware of it having happened in any of these cases. And so to my mind, there are collateral violations of the rules of professional conduct. There are primary ones from the wrongdoers, if there were some in these cases, and there are secondary ones by the fact that no one's done anything. So again, I'm not suggesting it's against the prosecutors, it's against the defense attorneys. There could be nothing wrong at all. And in fact, in some of the cases, I think it really could just be a series of unfortunate missteps. But it's not going to be 100%. And right now, look, if this were a doctor, I think at a minimum, you would want the hospital to think something is worth looking at a minimum, to review what happened. At a maximum, some people might be in the wrong line of work. This is a professional failure of the system. Again, nothing's happened in the vast majority.
Yeah. Okay. Well, I know during COVID, all the doctors are pretty much doing whatever they want. So that's it's a little scary. But the stuff that Ms. Armbrust was talking about is certainly disturbing. I'm just wondering if you think there might be a chilling effect on the ability of defendants to get representation if defense attorneys are now afraid that they're going to be potentially on the hook if they just don't have a good day in court.
Yeah, ineffective assistance is going to be a much higher bar, I think, in that respect. You're not constitutionally guaranteed quality. Frankly, that's not what you get, nor the experts or the spending on any of that business. That's the unfortunate scenario. And so, again, I'll read you just a couple of passages from the rules of professional conduct. The legal profession's relative autonomy carries with it special responsibilities of self-government. Every attorney is responsible for observance of the Maryland Attorney's rules of professional conduct. An attorney should also aid in securing their observance by other attorneys. Neglect of these responsibilities compromises the independence of the profession and the public interest.
Hey, this is Deborah.
Deborah Davis, you're not muted. Yeah. Okay. So yeah,
again, it's not going to be every case, but again, the fact that we've gone so far through the process, appeals, trial, post-conviction, maybe a writ of actual innocence, pardon applications, it got to the point, the government, they threw in the towel. The government has admitted you were innocent. We're letting you out. Not only that, we are paying you money. I just got 3 of these notifications from the Board of Public Works, totaling a few $1,000,000 just from 3 people. Again, you'll have to show me the articles where anyone has taken this information and applied the rules, are supposedly self-governing professional rules to these scenarios. I've not seen it.
Yeah, it seems like currently, the defense attorneys wouldn't know something was amiss, and so they've really already dropped the ball. The defense attorneys on these cases, so they may already be in violation of the standard of conduct. So, all right, well, thank you for answering my questions.
Delegate Shoemaker, then Cox, and McComas.
Thank you, Mr. Chair. Mr. Vice Chair, I mean, through your amendment, you've already gotten rid, I guess, of the part of the bill requiring the AG's office to do their own investigation, right? Hello.
Yeah, that's correct.
Okay.
And in fact, they expressed not hesitate. I don't want to speak for them. They didn't speak substantively on the process of that. In fact, I would say everyone I've spoken to acknowledged something has gone wrong here. Just what to do about it has been the thing to discuss. And so I offered to them that they would just physically move the papers from the compensation over to the professional boards that deal with this and let them figure out what to do with it. And that seemed, again, I don't want to speak for them, but that seemed not to trigger the same concerns that they had. And I assume, since the judge's concern was primarily about keeping their dominion, that they would see this as an agreeable model too.
Okay. And as you alluded to, we as attorneys are already under an affirmative obligation, right, to report violations of the rules of professional conduct to the Attorney Grievance Commission.
It's a strange thing. I mean, it does say that. And I was up late last night pouring through the preamble, the rules, the comments, and the rules of professional conduct. It's pretty clear you're not supposed to withhold evidence, and that if your colleague is doing it, you're supposed to notify the Grievance Commission. But again, I just was flipping through some of the Maryland exoneration cases. I saw 2 just last night where there was another person that confessed to the murder, and that person was made known to both the police and prosecutors. In some instances, they simply withheld that evidence, refused to let the person on the stand. I mean, the judges are complaining like, oh, how could we even look at the trial court? What did they have to do with it? Everyone should understand, just because the writ of actual innocence was based on one factor that was required to get them out through the law, does not mean there were not 50 other types of misconduct that happened in that case. Some of them were not available as remedies to get that person out, but they are nevertheless worthy of understanding. They involve judges who refuse to let some of that evidence in at trial. Again, I'm not saying they should be off the bench, but doesn't the judiciary want to know why that happened, why that judge came to that decision, and how someone ended up for decades in prison as a result, and now we, the taxpayers, are on the hook for millions of dollars. It's been an astonishing thing reading the testimony in opposition to the bill as I originally introduced it, which should have been a no-brainer on that count, but none of these supposedly self-regulating professional entities has, in the decades that these cases have been going on, lifted a finger to do anything. So I would suggest to you that this is the last best offer. And if I can't get it, honestly, I am content to sit there and file these third-party complaints out of the corner of my office. And I'm not joking. I'm happy to do that. A third party can file these complaints. But you know, and I know that the optics of that are terrible. Why isn't the judiciary or the bench or the bar intellectually curious about how these things happened? It's a dereliction of our professional duties.
Thank you, Mr. Chair.
Thank you, Delegate Cox.
Thank you, Mr. Chair and Mr. Vice Chair. I commend you for the intent of causing justice to be the focus and to make sure no one is unjustly convicted, et cetera. I want to remind everyone that I believe it was unanimous. Republicans and Democrats joined together on this committee to pass what you're talking about in terms of the remuneration, the payment to those wrongfully convicted. Now, here's the problem, though. There's two issues that I see. Number one, isn't it true that every single police officer has to arrest someone with the knowledge that they are innocent until proven otherwise? Isn't that true?
I'm not sure that's their mindset, but okay.
Doesn't matter. It's the law, right? I mean, the law is every single arrest is an innocently presumed person until proven otherwise.
That's supposed to be how it goes. Yes.
Okay. So then secondly, in the context of attorneys, and I'll confess, I'm not like Delegate Shoemaker, who is a defense attorney all the time. I've done this when usually a mom comes to me and pleads for help for her son or daughter. But in the context of criminal defense, every single action under your bill, from what I'm reading, is someone who received a plea. Isn't that true?
I'm not sure.
It says here okay, so this is an honest question. I'm not trying to catch you or trick you or anything. It says here, if the conviction—
The self-contributing factor of someone having taken a plea is not one of the things that will bar you from exoneration in Maryland. And there's a long history of coerced confessions and things like that.
Okay, I'm not talking about any, okay, inclusive, I understand. I'm talking about the exception to your bill is every single person convicted by a jury may not proceed under this bill, correct?
I'm trying to follow, walk me through here. Where are you going with this?
Okay, so here's where I'm going with it. In the few times that I've done criminal defense, have worked out plea deals because either the person truly believes that, tells me they're innocent and I believe they're innocent. And so they get a plea deal, or whether it's Alford or Nolo Contender, or they get they plea out to a lesser charge because, under advice, it's like, well, yeah, they're throwing the book at you and most of it are lies, but this one, they might get you on, or whatever the discussion is. And the defendant then makes a judgment call and says, you know what, I'm going to plea out to that lesser charge. And the end result is they don't face, whatever the max of time in prison is. They get a deal. They get a deal for whatever the prosecutor and the defendant finally agree to. My concern is under this bill, how would Delegate Shoemaker, criminal defense attorney, ever want to recommend a plea deal at this point? My concern is you're going to increase people just pushing it to jury trials. I mean, that's what I would do. I'd say, look, you can do what you want, but I'm going to a jury trial from now on. You're going to face 100 years, you're going to face 50 years, you're going to face 20 years. Because I'm not going to be exposed to advising you ever to make a plea, knowing that the entire system is going to be investigated for the plea deal.
I'm not sure that's quite a likely outcome from how this is going to go. And again, I think you're overcomplicating it. These are extraordinary cases. They don't come very often. At this point, we have a pileup of them because over history, there might have been a couple or a few dozen that might be in this posture. But it's real simple. There should be a disincentive for people hiding evidence that leads to people in decades for prison, and the taxpayers on the hook for millions of dollars. And it's not currently being pursued despite it being on paper. It's a very simple problem to solve.
Well,
on the record. A lot of this misconduct is on the record. It's on the official record.
Well, I certainly agree with you there. I mean, no one should be hiding evidence. That's preposterous. It's illegal. But I just am concerned about.
But we're all members of the bar. We took an oath to report this sort of behavior and do something about it. I was reminded of it last night, and I just don't think it's happening. So again, we are all failing at our stated jobs.
Well, I understand. I'm just concerned that when you mess with the three separate branches, I mean, like the judiciary opposition is that now you have.
We're inviting the judiciary to mess with their own branch as they've requested at this point. Again, I can't guarantee they'll do anything. The track record has not been that they have saw fit to look into this stuff. So
are
maybe they won't do anything.
So with your amendment, are they now on board? Because I don't see that. I see it going to the Attorney General, which is a separate branch.
I forwarded this amendment. I warned everyone about this amendment, in the last few weeks. I had separate conversations with some prosecutors, the judges, and they told me these concerns. So I had an amendment ready for today that would be preemptive of what they were trying to do. And I actually think it ought to be one that addresses in full all of their concerns, unless what they are simply saying is they don't think there should ever be accountability for the people involved in these cases. If that's the case, that 0 of the cases would warrant some sort of look, well, then I think we're going to have to agree to disagree. And I think the taxpayers might have an interesting perspective on that, since they're the ones now on the hook for this. But again, I guess if they're up next, we can ask them how they feel about the amendment. But I honestly think it's hard for me to see how it does anything different than what they've asked. To now just let's let them know something terrible has happened. Give the documents to the people whose job it is to review this stuff. Let them decide if a professional standard was breached.
Okay, thanks so much.
Delegate McComas, please.
Thank you, Mr. Chair. I have a question, and I don't necessarily expect you to be able to answer it, Delegate Moon, but I remember when Kurt Bloodsworth, he wrote a book, and I think he was on death row for a period of time, and then he was finally granted innocence. And I do know the prosecutors, they were still convinced he was guilty, and the judge ended up putting some of the evidence in his closet until DNA became able to be analyzed. And that I think that is how he was exonerated. I think my concern is some of these bills that where there's been the folks that are in prison, incarcerated, have been found innocent. It's taken years, and the prosecutors may have passed away. They may have retired. The police officers may have retired. The judge may have passed away. I guess what I'm thinking is that, yes, it would be very good to know exactly how things went down. But I think, to require the professional organizations to analyze it, I mean, that there may be no ability to disbar or slap wrists or anything, because there's so much time has passed, particularly with some of the recent exonerations where people have been in jail for years. So I guess what I'm kind of thinking is maybe a task force to look at this and get the different players at the table and see what would be a good policy first before we decide that this is the answer. I'm not sure we're there, but I think you do point out a significant thought that we really need to figure out what went wrong. And I think one of the things may be that there's improper supervision within the state's attorney's office, just because a lot of times different lawyers have the case and then it goes to somebody else, information gets lost. There's no talking, that maybe the files aren't perfectly the notes aren't recorded. I guess what I'm saying, I'm just not sure we're ready for what you want to do right now, because it may not be the right answer. But I do commend you.
I have to beg to differ because
Isn't that so, was what Delegate McComas meant to say at the end of that. Could we also please, everyone, questions would be nice. Would be wonderful. And thank you very much. The Vice Chair.
Thank you, Mr. Chair. No, I'll take that as a question though. And the first one is this: is it some of these cases are, to be sure, old. But look, I mean, in the world of prosecution, you have war crimes, people who are prosecuted years. It makes the prosecution that much more challenging, to be sure, but not impossible. And it's certainly not a reason to not uphold justice because of the passage of time. If anything, it's a little bit more disappointing to the system if someone, quote, got away with it by virtue of just simply time having passed and people having forgotten. Thankfully, this past winter, we had a live example from Maryland where a state's attorney, who was an elected state's attorney, was disbarred in their retirement due to withholding evidence and lying about it in court. I actually was astonished that this case had popped through, and it actually strengthened my resolve to introduce this bill, which was just in R&D stage at that point, because it was a sign that, my God, the system is alive somewhere for someone. Somehow something happened. And so it is possible in Maryland. It's not going to be true for every case. I heard from some police who were I was talking to about this, and they said, well, we have one of these cases up in Baltimore, and it's led to a civil suit. And so some of these officers are being depoted decades, into their retirement because it was such an old case. But again, that's what the system is for. And I wish a task force were the easier answer. But as I've mentioned, the entities that I've spoken to are not interested in creating more process. It seems using the existing process fits their MO much more closely.
Are there further questions for those who are testifying in favor of the legislation? Seeing none, we thank you all very much, and we're going to go to those people who oppose the legislation. We'll ask them to be brought into the room. Stephen Kroll, Joe Riley, Shaoli Katana, and Yolanda Vasquez. Coming in. All right, let's see if we can find Mr. Riley. Okay, and I understand it's actually the state's attorney is here, Mr. Gibson. So that's fine. We'll hear from Mr. Gibson instead, as opposed to Yolanda Vasquez. Let's, Mr. Riley, you have, this is a new bill, so 2 minutes, please.
Thank you, Chair Clippinger, Vice Chair Moon, members of the committee. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. We seek an unfavorable report on House Bill 249. Quite frankly, I can't think of a bill that has been more an attack on prosecutors and totally has no regard for the harms that defense attorneys sometimes cause in these actual innocence cases. Every year, more incarcerated persons are granted new trials because of ineffective assistance of defense counsel than writs of actual innocence. And this bill does nothing to address that, even though persons might have been incarcerated for years. And the entire discussion of this bill was, well, it's needed because nothing is done in these cases. And Delegate Moon goes and undercuts his own argument by bringing up the Harford County case where something was done. These cases are brand new. They're decades old, but these writs of actual innocence are brand new. The Innocence Project referred to a Talbot County case that I think the new trial was granted in 2020. Well, if there has been misconduct in that case, isn't it their responsibility to file an action against the Attorney Grievance Commission? If something has been done, they certainly have the ability to do that. Why haven't they done that? This bill is not needed. It's another attack on prosecutors and totally disregards what defense attorneys do. It is an affront to say that the harmed parties can't take care of this action themselves. And furthermore, this bill would go against public policy because assistant state's attorneys and state's attorneys cycle in and out of the office. It's a lifetime decision for me, but it's not for everyone else. And this bill only has remedy against the state's attorneys' offices themselves and not against the state's attorneys who might have been in office at the time. This could be used as a political cudgel against opponents in a contested election where incumbents are going back and forth. This is a bad bill, and we seek an unfavorable report. Thank you.
Thank you very much. We'll go now to Steve Kroll.
Mr. Chairman, members of the committee, good afternoon. My name is Stephen Kroll. I'm the State's Attorney Coordinator for Maryland. I'm the Maryland State's Attorney's Executive Director, and I've been prosecuting cases since 1984. First to Vice Chair Moon. He might have known and told everybody, but he didn't tell me this bill was coming, and my number is public, and we've known each other for a long time, Delegate Moon. All you had to do is pick up the phone and call me and not send the amendment at 4 o'clock yesterday afternoon. So if this bill was coming, I know Mr. Potashny called you last week. Everything's coming, but I wasn't phone called at all, and I really appreciate a phone call ahead of time. Second, I did a Lomax hearing in December. I was involved in it. The Assistant Attorney General was sitting right next to me. They are part of this case. By referring the case to the Attorney General to do anything is a conflict of interest. If you were part of that Lomax hearing or understood it, you would know that. They can't do anything. They're part of the hearing. They ask them to defer a case or do anything part of the case. They are part of it. It is a conflict. This bill is wrong in many occasions. Second, anytime a referral is to attorney grievance, it is money out of our pocket, money out of the state's attorney, the assistant state's attorney's pocket. The Attorney General will not defend us for free. It costs us. Ladies and gentlemen of this committee, you see how upset I am about this bill. I was not contacted. It's ill-fated. It's wrong, and it should be given an unqualified and just not reported properly. I'm uproared about this, and I'd ask for an unfavorable report. Thank you.
Okay, we're going to go now to Shirley Katana from the Bar Association, please.
Thank you so much. Good afternoon, Chairman and members of the committee. My name is Shirley Katana, and I'm a director at the Maryland State Bar Association, where we represent thousands of attorneys and judges across the state. And we did submit an unfavorable testimony requesting an unfavorable report for HB 249 as it was written prior to amendment. And I understand the investigative portion has been taken out, but to note our concerns there, there's clearly a separation of powers issue for the Attorney General acting as the executive branch to investigate the judiciary. We also had several concerns about attorney-client privilege, and as there were no parameters for the general's investigations into defense attorneys and prosecutors, there was a serious concern about that privilege being an issue. We already have two entities, the Attorney Grievance Commission and the Commission on Judicial Disabilities, which investigate attorney and judicial misconduct. They have very clear procedures in the Maryland rules, which state what standards of proof are required, findings of fact, and how any results from these investigations are then referred to the Court of Appeals. And the proposed legislation as it was written did not provide any of that information. And so for those reasons, we did request an unfavorable report. I did receive notice of the amendment, that an amendment was coming yesterday during the day. And so what I would say is that we'd be glad to receive new language to work together to talk about this issue, as it is very important, and happy to provide a further response. Thank you.
All right. State's Attorney Gibson, please. Rich Gibson for 2 minutes.
Thank you. Good afternoon, everyone. I'm State's Attorney Rich Gibson. I'm State's Attorney for Howard County, and I'm the president of the Maryland State's Attorneys Association. I guess I'll start with a question, which is how many bills would get passed if members of the legislature were exposed to civil or administrative sanctions for the collateral impacts of harms caused via legislation that they imposed or they supported? Members of the legislature enjoy qualified immunity, so they're not exposed to any liability for the financial harms from the positions they advocate for on behalf of the community in furtherance of the values that they have, right? Without any fear of repercussions. And that's a good thing. That's what you want, right? HB 249 poses significant public safety risk as drafted because it requires an automatic referral to the Attorney Grievance, Bar Council, Judicial Disabilities, or Police Accountability Boards in reference to wrongful conviction order. This will create a chilling effect on the pursuit of difficult cases. Prosecutors should have no hindrance in pursuing factually challenging cases, provided there's sufficient evidence supporting probable cause and sufficient evidence to prove the case beyond reasonable doubt. We're not talking about the malicious prosecutor, the rogue judge, or the officer engaged in wrongful conduct, right? And that's because this bill will create an environment where prosecutors will only go forward in cases where they believe they can prove guilt to an absolute certainty. And what defendant would not pursue a wrongful conviction case under this system? They have nothing but time. Additionally, the judicial exposure is one-sided. It incentivizes the court when ruling on cases to always side with the defendant, because ruling in favor of the state, regardless of how righteous the state's position is on that evidentiary element before the court, would expose them to risk, expose them to potential review. And finally, this bill is trying to create remedies which already exist. So it's a bill and solution. It's a solution in search of a problem, because currently there's nothing stopping any person from filing a claim with attorney grievance, disabilities, or police accountability board. The distinction is this bill creates an automatic referral, right? So it's something that isn't pursued by the person who was harmed, rather it's just automatically sent. And I think that is again problematic, in that there are instances where there might be a wrongful conviction finding that's separate from actual innocence. Those two things are often blended, but they're actually separate and distinct. I would urge an unfavorable report for this bill and welcome any questions. Thank you.
Thank you very much. Are there questions for the panel of those people in opposition? The Vice Chair.
Thank you, Mr. Chair. Everyone makes reference to the existing process. I'm curious, since the rules of professional conduct require us to refer misconduct we've seen, how many state's attorneys' referrals have come from within to the Attorney Grievance Commission on these cases? I see that there have been cases in Howard, Montgomery, Prince George's, Baltimore. I'm curious if anyone's aware of anything that's happened to any of the attorneys involved in any of the Lomax, writ of actual innocence, any of these pardon cases where anyone has taken any action with respect to attorney grievance or judicial disabilities. I'm curious. And if the answer is no, that's question one.
I'll answer.
Okay. And the second question is this. Are you committed for putting this mechanism aside? You've now seen two mechanisms. One as drafted. People don't want the AG investigating separate initiation powers, blah, blah, blah. I offer a second one. Just send the documents to the existing process that you guys are talking about, the existing remedies. Now a third one. You don't like the AG being the person because of conflicts. It could be BPW or the treasurer. We could find a third entity to peg to sending the documents. Are you opposed to anything happening at all on this topic?
Question one, is the vice chair suggesting that we file attorney grievance based on newspaper articles?
I'm just curious. No, on the record, people.
I don't know of any of these cases in Caroline County. So are you suggesting that I write
your colleagues? Your colleagues are testifying that the system.
Hold on. We're not going to talk over each other. There's going to be a question. There's going to be an answer. And don't make me pull this committee hearing over. All right. Thank you very much. Let's do this. Mr. Vice Chair, I believe you've asked a couple questions here. So I'm going to give Mr. Riley the chance to answer it, and then we'll go back to another question. Mr. Riley.
There haven't been any allegations of Lomax hearings in Caroline County. If they were, they probably would have involved the now deceased former state's attorney. So I don't know anything about that. Secondly, as to your question, I'm not going to comment on amendments that I haven't seen or that haven't been submitted to me. So it's just a futile exercise that I'm not going to.
There, you've seen them. I emailed them.
No, I haven't. You actually didn't attach them. I can send you the email. There's no attachment.
All right, Vice Chair, do you have a further questions?
Well, it's a two-part question. Are the people who are claiming the system works aware of anything that's happened in any of these cases, a preceding attorney grievance commission inquiry, something where the process they're pointing to was actually triggered? And if not, Are they willing to support coming up with me? Again, we've got some time sitting down with me to actually make a system that does that.
If I may answer the question,
Yourself,
Delegate Moon.
the Harford County case, you mentioned it yourself.
Mr. Kroll now.
Yeah, thank you. You know, Delegate Moon, had you contacted me, I would have told you about the case that I had, where the defense attorney was successfully post-convicted for ineffective assistance of counsel, and a Lomax hearing was followed after that. So that case is pending right now, but had you called me, I'd have sat down and talked to you about the procedural effect about what happened and what we could do as a result of that. So I ask you, and I continue to say, we open the conversation even after this hearing to talk about it. Always happy to talk about it with you. But to file bills and amendments without discussing it with us is just plain wrong.
And it's State's Attorney Rich Gibson. Just to answer Delegate Moon's or Vice Chair Moon's question, I'm open to talking to anyone. Again, I got an email that was forwarded to Steve Kroll at 4:44 yesterday evening. That's the first communication I've had with you at all about this. And so there was no conversation there. I'm willing to talk to anyone, and I'm willing to have conversations. Again, from my perspective, the priority is ensuring that we do not create a chilling effect on the pursuit of difficult cases by creating an environment where prosecutors are fearful to go forward and therefore don't go forward, thus creating a cycle of violence in our communities because we're not responding to the threats that are existing in this space. If there's a rogue prosecutor, a rogue judge, a rogue defense counsel that's doing things that are inappropriate, I am not opposed to utilizing the existing remedies to address those things. Again, it was a question posed by Attorney Joe Riley, or it was mentioned in his statement to you. There is some onus placed upon the person who believes they were harmed. If you believe that a judge ruled in a way that was improper, or the attorney did something that was improper in terms of hiding evidence, or I don't know, something horrific that undermined their pursuit of justice and wrongfully impacted this person, they have the ability to file a claim. And defendants, I can tell you from post convictions, they and collateral attacks, quorum nobuses, et cetera, they have the ability and they do file. Why they don't file this particular claim, why they don't pursue this, that could be an assessment of their chances of success or things of that nature. But there's no shortage of defendants filing claims against the state or councils to undermine their convictions. That happens all the time, regularly.
I just want to clarify, Mr. Chair, if you'll indulge me. We are talking about cases where prosecutors had a confessed murderer in front of them and withheld that evidence. And as a result, the person who did not commit that murder was put in jail for decades. We, the taxpayers, had to pay money, and the actual murderer is out on the streets doing God knows what. I just want to be very clear about what cases we're talking about here. These are not the questionable cases. The trigger in this bill is people who are compensated. And again, sometimes this misconduct is on the record. The people who were put in prison may have grace about what happened to them, but the supposedly self-regulating profession should not. I don't think that's that difficult. Again, I'm sorry to be upset about this. I've been 20 years on this project. I'm happy to sit with you after to figure a way forward. But the fact of the profession turning a blind eye to this, again, right now, to me, this is a devastating feeling when the government, us, cannot own up to one of the most catastrophic failures of the justice system and say, maybe we should look at the files. Maybe we can improve. Maybe someone messed up and maybe someone didn't. But it's astonishing to me that every party to this, the Bar Association, the judges, the prosecutors, really, you want me to include the defense attorneys? I'm happy to do it. In the amendment, they're in the bill. The whole thing gets sent over. Every single one of you is telling me there's no problem when these cases happen. Okay. Again, we will have this conversation offline. Thank you.
So just to be clear, that's not what we're saying.
There's another 3-minute.
Hold on, Mr. Okay, wait a second. We'll go with Mr. Gibson first, then Mr. Riley. Mr. Gibson, please.
Just want to make sure that it's clear. We aren't saying that there's no problem, and we aren't saying we're not willing to have a conversation. The issue is, in this instance, there was no conversation. A bill was put forth that we saw problems with. If there's a conversation, We are willing to talk to you or anyone. We agree to attempt to solve these problems. In this instance, there was no conversation. We simply were not spoken to. This was shared with me, at 4:44 yesterday, and it wasn't sent to me. It was sent to Steve Kroll, right? So there was no.
Yeah.
I'm willing to talk, but there was no conversation. I think all of us are willing to talk, but the conversation, it's the cart before the horse.
I apologize. I talked to one of your bunch, not all of you, so that's my fault. But again, we will have a conversation. We will continue this if you are so willing.
Let's go now.
Absolutely.
Delegate McComas. We'll go to Delegate McComas now.
I have a couple questions. One, are there other states that the Innocence Project witnesses are familiar with that have any kind of examination after the innocence, that the person that was incarcerated has become declared innocent? I mean, like what Delegate Moon is putting it through here. Do they have any extrajudicial examination as to what happened? Does anybody know?
I can answer that, I guess, briefly, but it's not.
Wait a minute. This is a question. This is a question to the panel in opposition. I'm sorry. I'm not going to do that. Does anyone on the panel in opposition have an answer to Delegate McComas's question?
I have no idea.
Okay.
No idea.
Okay, and I guess the advocates have left. Okay, the other quick question, and this is for Attorney General State's Attorney Gibson. What you said there was a distinction between the wrongful conviction and the innocence, the declaration of innocence, and I wondered if you could explain that in simple terms.
Sure. So there's a distinction between the evidence upon which you were convicted was in error or was improperly analyzed or was improperly handled or was not turned over appropriately when it should have been, and the fact that the person did not actually commit said crime. Like those are two actual separate things. So you can be guilty of the actual offense, but the evidence related to your guilt that was used by the state or that was gathered by the state was mishandled or improperly handled or not turned over when it should have been in terms of the way in which it was produced. And that can result in you being wrongfully convicted, but not being actually innocent. They're separate.
Okay, thank you. Thank you, Mr. Chair.
Thank you. Delegate Grammer, please.
Thank you, Mr. Chair. I just wanted to make a request. Can someone maybe send me documentation about how issues of professional conduct are currently handled so that the non-attorneys on the committee can be a little bit more educated about how these issues are handled currently?
I believe that there are a couple pieces of legislation that are being considered and may be coming in the hopper regarding to issues related to attorney grievance. It's my hope, and it was I discussed this a little bit during the interim with a couple people, that we would have a briefing on how the attorney grievance process works. We will certainly try and get that in this year. Did I mention that everyone needs to drop their bills so that we know how much time we have to do these things? Seems like a good time to mention that. All right.
Thank you, Mr. Chair.
You're very welcome. I don't see further questions for the panel in opposition. And with that, that concludes the hearing on House Bill 249. Thank you all very much for that. We will go now to Delegate Juanica Fisher. Delegate Juanica Fisher, and House Bill 122. House Bill 122. This is a new piece of legislation. There are 1, 2, 3, 4, 5, 6, 7 in favor. Well, looks more like 6 in favor, but we're going to find out here in a moment. We'll hear from Delegate Juanica Fisher and then everyone here testifying in favor as one panel, and then we'll take questions. So that'll be Kim Haven, Christopher Dews, Jason Wright, Mary Denise Davis, Matt Parsons. There is also an entry here for Maryland Legal Aid, doesn't have a name connected to it. So we'll have to figure that out here in a minute, I suppose, to see if there's someone here from Legal Aid to testify. But with that, Delegate Juanica Fisher, this is a 3 and 2, 3 minutes because it's a new a new bill, and we'll go from there. Delegate Juanita Fisher.
Thank you so much, Mr. Chair, for that. Saving the best for, am I last? I don't even know, but okay, I'm not last, but best for the middle. Good afternoon, colleagues, Chairman Clippinger, Vice Chair David Moon, and the hardest working committee in these parts of Maryland and the Maryland General Assembly, House Judiciary Committee. It's my pleasure, It's my pleasure to introduce House Bill 122, the expungement of records expansion. This bill attempts to address the issue of expungement in our community. The expungement of records waiting period in House Bill 122, the goal is to give people of Maryland a fresh start when it comes to their records and the time period, and change some compliances with mandates. The main goal of HB 122 is to change the original amount of time of 3 years to 18 months that one has to wait to be able to seek a certain expungement for the record under certain circumstances. I apologize. There would also be a petition for expungement, which includes a specific waiver and release form explaining certain circumstances to individuals. Speeding up the process will allow civilians for quicker access to expungement of their records to move on with their lives and be more involved in their communities. It also allows for more educational benefit and opportunities here in our state. The Center of Community Alternatives stated that 66% of colleges gather information, for example, like criminal records for their admission process. Marylanders, regardless of how small their offense they've committed, can be shunned away from opportunities due to their past records that we all know. Opportunities such as employment, assistance, and education. In our state alone, having a misdemeanor can result in one not being able to even grasp a barber and a cosmetology license, as we've heard on previous bills. This bill would allow individuals to receive expungement on an expansion of topics, not just ones that they were acquitted on, but probation before judgment, nullity prosequi, and other dismissal charges that would be encompassed in this bill. I have an esteemed panel that would help with this legislation. I'm very open to the committee working on this bill to make it a better product for all of us. And I will keep it short because I've got a great panel. So thank you all. And that's it. So thank you.
Okay, if we could hear now from Kim Haven, please, for 2 minutes.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Kimberly Haven. I'm here on behalf of Forward Justice Maryland. We are a Maryland-based organization focusing on decarceration and reentry. We are in support of HB 122. I cannot tell you how important this legislation is and how important a fresh start is. Sometimes someone's past should not be used like a sledgehammer to drive them into the ground like a tent peg. And this bill is critical to help people move past that criminal record. This bill does not remove or expunge convictions. It does, however, remove confusion when an employer, a landlord, a bank, an insurance company runs a criminal check. For charges that are not prosecuted, dismissed, or not guilty, they should be expunged, not added to the sledgehammer. We agree that employers need to know who they're hiring, but they don't know how to read these criminal records. Reducing the amount of time before someone can file for an expungement, or expanding the topics that someone can seek that can seek the expungement for, is critical to helping people gain that fresh step, that fresh start. We believe that since most people don't know how to read a record accurately, employers are missing out on hiring great employees. Individuals are missing opportunities to rebuild their lives. Barriers for individuals rebuilding their lives is something that I know that is of concern to the members of this committee. What we want to do is eliminate these barriers so that individuals can contribute to their communities. They can provide for themselves, they can provide for their families and meet their obligations. To deny that, to keep barriers in place that only serve to stratify and stigmatize these individuals is antithetical to what our state believes in, and certainly what we as Maryland citizens believe in. For these reasons, we ask for a favorable report on HB 122. Thank you.
Thank you very much. Could I please hear from Christopher Deuce for 2 minutes?
Fantastic. Thank you, members of the committee. My name is Christopher Dews. I'm the Senior Policy Advocate of the Job Opportunities Task Force here today in support of House Bill 122. Now, our mission, as it always stands, is to help lower wage workers advance to higher wage jobs. And so the access to criminal record expungement is vital. What's interesting about this piece of legislation is that it's focusing on non-convictions, the additional probations before judgments and steps to go along with legislation that you guys have already passed and moved last year, which was acquittals, dismissals, and no pros. So as you already know, a criminal conviction or any type of criminal record that appears is a massive barrier to employment, housing, education, public assistance, as has already been mentioned. What you may not already know is that 1.5 million Marylanders have a criminal record that would appear on a routine background check, many of which are non-convictions. A probation before judgment means that a person has been placed on probation before any criminal judgment has been entered against them, which means it's a non-conviction. The same with the stet. It has been let stand. So that it's literally listed as inactive in the court. That being said, the fact that that becomes a barrier to employment, since about 84% of Maryland employers do background checks and deny employment on that basis, we need to add probations before judgments and stets to this list of automatic expungements that you all have already done a wonderful job of passing. That being said, as has already been mentioned, many employers do not know the difference when they pull up a criminal record. I can speak to that personally because I ran a workforce development program, and I remember people coming in, specifically one young lady who was very talented, and I was confused as to what a stet was. She was trying to explain it to me. She said that's what her charge was, and I didn't know if I could actually offer her the position because of that specific charge. I had to do all this research. All I'm saying is that the average employer is not going to take that kind of time out of their lives when doing the hiring process. So we need to add this list to the docket that's already there. And I thank you all for taking the time to listen. And of course, we urge a favorable report. That wasn't already clear.
Glad you got that last part in. That's fine. Jason Wright for 2 minutes.
Chairman and distinguished members of the committee, thank you for the opportunity to testify in support of House Bill 122. My name is Jason Wright, and I'm the Workforce Development Project Paralegal at Maryland Volunteer Lawyers Service. In my program, we partner with local nonprofits that offer job training skills to those who would otherwise not have the opportunity. My organization contributes by providing legal services as an addition to the other wraparound services trainees already receive. As most of our clients are in need of expungement, last year I had the honor of testifying in favor of this bill's predecessor, House Bill 238. I shared the story of one of our clients, Deborah from Caroline Center, who, like all Caroline Center trainees, needed a totally clean record in order to be certified by the nursing board. With a bit of work, we were able to remove all the charges from Deborah's background, and in the end, she was immensely grateful, going so far as to offer me a thank you note that I still have today. However, each time that I look at that note, I'm struck by the thought that she should have never needed to send it in the first place. Instead, those charges should have been removed automatically, in no small part because she was never even convicted of a crime in the first place. Last year's automatic expungement bill was a meaningful step towards streamlining the process for certain non-convictions. Expanding that law to include other, currently excluded non-convictions, such as stets and probation before judgments, would greatly benefit all Maryland. Most importantly, this expansion would include those who, unlike Deborah, were not fortunate enough to interact with a legal services provider like mine. And while I do enjoy my job, special legal assistance for navigating the sometimes lengthy process of criminal record expungement should not remain a barrier to the employment, housing, or even education that could make all the difference in someone's life. That is why I'm asking for all of you to support House Bill 122 for expanded automatic expungement. Thank you.
Thank you very much. Mary Denise Davis for 2 minutes.
Hello, everyone. Mary Denise Davis with the Office of Public Defender. The Public Defender does support House Bill 122. The reason why we support this bill, and we've supported the reform and movement forward with expungement, is for the simple fact everyone has talked about how much of a difference it makes in individual lives to have these records removed. And last year with automatic expungement, we made huge steps forward. But there's still some confusion left, because when we talk to a client, when other service providers talk to clients, we say, yes, your favorable dispositions are eligible. But wait, no, not really, because you have a PBJ or a STET. And even though those are favorable under the law, those don't fall within the automatic expungement. And so I think what we would recommend is that those two dispositions be included in the automatic expungement bill law. The other thing I would say too is I looked at the district court report for 2020 to see how many stats there were, and there were 13,970 stats entered in district court in Maryland, and probation before judgments, there were 7,253. That's just for 1 year. That's a huge number that would affect a lot of people if those were automatically expunged. I also agree with what everybody says when there is confusion. What is a STET? What does a PBJ mean? All those things that you have to navigate and you don't understand. The employer, the landlord, the school is simply going to say, I don't understand. You have too many stats. What's this probation before judgment? And they might move on to the next person. So that is why the Public Defender's Office strongly supports House Bill 122 and requests that stats and PBJs be included.
Thank you very much.
Thank
Tim
you.
Darby, please, from Maryland Legal Aid for 2 minutes.
Thank you, Chairman Clippinger and members of the committee. My name is Tim Darby, and I'm a staff attorney at Maryland Legal Aid with the Community Lawyering Initiative. We bring legal services into communities to ensure that even our most marginalized citizens have access to advocacy within our justice system. Since 2016, we've represented over 10,000 expungement clients and filed over 50,000 expungement petitions. The General Assembly made history last year by codifying Criminal Procedure 10105.1, which will automatically expunge cases for thousands of Marylanders who were never convicted of a crime. However, Marylanders who have cases with STET and probation before judgment dispositions are not afforded the same benefit, even though their cases also did not result in a conviction. This bill puts every Marylander on equal footing, regardless of their knowledge of the legal system or their access to an attorney. This bill will expunge thousands of cases that are already eligible to be expunged, but for filing a petition, which for too many is an inaccessible hurdle for a variety of systemic reasons. I hope this committee will give House Bill 122 a favorable report. Thank you, Mr. Chair and members of the committee.
Matt Parsons, please, for 2 minutes.
Hello, Mr. Chair, Vice Chair. Good afternoon, everyone. Thank you for allowing me to speak in favor of this bill. I am the community lawyer at Baltimore Action Legal Team, or BALT. In my career, I've had the privilege of providing legal services to community members and supporting re-entry for returning citizens. As others have alluded to, I'd like to draw your focus on the value of expungement access for directly impacted people. Most often, those who I am helping are disenfranchised by our society, mostly Black and Brown people, impacted often from birth by the criminal justice system, branded with a criminal record, and frequently incarcerated. Because of the existence of a record, they're not only socially marginalized, but especially economically marginalized. Life-changing opportunities such as education and access to quality jobs are withheld. And on top of all this, if you lack access to an expungement, there's seemingly no way out of poverty. At Civic Works in Baltimore, I worked with returning citizens who are training for family-sustaining jobs. These people worked with incredible determination and grit just because their circumstances demanded it. They faced compounding struggles from unstable housing and lack of food access to unreasonable child support payments and even more, all of which stem from a lack of access to job and perpetuate the cycle of poverty. But despite all their grit and determination, that unfortunately isn't always enough to overcome systemic barriers in that reality. As a community lawyer, I currently offer expungement services to people, but although I am able to help some who face these same struggles, too often someone is unable to access expungements for a seemingly arbitrary reason. The apparent message is that people with a criminal record are not worthy of the same opportunities which more privileged members of our society freely enjoy. In this case, expanding access to expungements for stats and probation before judgments will create more racially equitable outcomes in Maryland, alleviate the unjust burden of a criminal record for many, and ensure stronger families and communities in Maryland. As such, I urge a favorable report on this bill from this committee. Thank you so much for listening, and I'm glad to answer any questions.
Thank you very much. That concludes those people who wish to testify in favor. We'll take questions to the panel now. Delegate Cox, followed by Delegates Cardin and Arakan. Delegate Cox.
Thank you, Mr. Chair, and good to hear your bill here, Delegate Fisher. Real quick, I think I heard you say that you were changing the statute to 18 months. I don't see that in the bill. Is that something I misheard?
Sorry, EVI. Yes, I don't know why I said that. I'm sorry.
Okay, that's fine. I'm
I'm sorry. It was just the include. I think I got confused. I was reading my notes on my prior bill. I'm so sorry.
Okay.
I was I thank you for that. This one just includes the PBJ instead. I don't see a time, unless anyone on my panel, but I don't see a time change in the bill. I'm sorry about that, Delegate Cox.
Okay, no, that's fine. And then the second question is, isn't it already the case where PBJs and STETs may be expunged upon application once the terms of those conditions are met? You're just changing it to being automatic. Is that your understanding?
Yes, and to be included, yeah.
Yeah, and so my concern with that is the opportunity to possibly, in two ways, to hide inappropriately in the context of potential litigation. Now that quasi-immunity has been changed to allow constitutional torts against officers, I think this could potentially open the door for more lawsuits against police officers when you have PBJs and STETs, which are, in essence, these are guilty people that got a good deal. And now they can get those potentially expunged and go after officers for quasi torts. Do you see that there's a concern there at all? Have you heard any?
I'm gonna let my panelist, Mr. Wright, answer that question because I feel like his face is telling me that. But no, I don't see that concern. But I'm gonna alley-oop to Mr. Wright to see what his response would be.
I was shaking my head at the moment where you're saying essentially guilty. And, you know, for better or for worse, we don't have a justice system that has essentially guilty. These are non-convictions in both cases, full stop. And as you said, they're already applicable for expungement. And all this bill would do is streamline the process, free up our legal system, free up our service providers. It's all going to be a step in the right direction towards efficiency. And I think that that's going to be the main outcome of the entire thing.
Well, my concern though is it's not, they're not innocent people, because when I get a PBJ for someone, for instance, there's always a guilty entrance. They admit guilt in exchange for the plea deal of a probation before judgment of guilt, which would then require a statutory conviction, and that would obviously harm their record if it usually is provided in a situation where it was not someone who's repeatedly, a criminal. So I think that would be a concern, but my main concern, though, I guess, isn't able to be discussed in depth. But I don't want to see police officers,
Delegate.
I don't want to see police officers sued more under the quasi-immunity change with the constitutional torts with this change. That's my concern.
Delegate Cox. I don't, Mary Denise Davis with the Public Defender's Office. I don't know if this would address your concern, but about this doesn't change. This doesn't allow somebody to the automatic expungement prior to 3 years, and the 3-year period is still happening. So any lawsuit that somebody would bring, if they try to file it, I guess what I'm trying to say is, it's not, they're not able, they have to file that lawsuit within 3 years, the general tort liability and filing a claim. And so this isn't expunging anything prior to that. So I think your concern regarding being able to file a lawsuit wouldn't necessarily apply. And also keep in mind, we've had for quite a while release without charges, which, there is no need for somebody to waive the right. And that certainly hasn't opened the floodgates of litigation. And I just wanted to point out to your point about probation before judgment, the case law is clear. That is not considered a conviction in Maryland. So yes, there was a guilty finding, but as the case law clearly indicates that when the judge strikes that guilty finding and imposes that probation before judgment, it is a favorable disposition. And that's part of the problem, is that people in the know sometimes will also refer to as PBJ as a conviction. So I think that's what everybody was testifying on the panel regarding employers and landlords and, schools. When they see a PBJ, they just want to jump straight through to conviction. And that's what we're trying to address. But hopefully that answers your question about police officers, because it's not shortening the period of time before that expungement is being granted before the 3 years.
Well, I appreciate that. And I do know that there's a statute of limitations for 3 years, but the problem is there are also continuing torts and discovery rules that could allow for lawsuits, as well as the fact that, and I've not called it a conviction. I was talking about a guilty, someone who is in fact, who has pleaded guilty, could then have a potential ability to then sue police officers. So that, add an added benefit to them rather than an equal playing field. But I appreciate the time. Thanks so much.
Okay, thank you.
Delegate Carden, please.
Thank you, Mr. Chairman. Thank you, Ms. Delegate Fisher, for putting in the bill. I love this bill. First of all, if you did have an issue with what Delegate Cox was talking about before in terms of the waiver, perhaps you could find out if it's possible that in order to accept a PBJ and have it automatically expunged, you would have to sign a waiver right there in court. That might be a way of dealing with that. Number one. Number two is, that we've had some disastrous unintended consequences from the Barron bill that automatically takes people off of case search, even though it doesn't expunge their records. Perhaps if we decide that we're going to look favorably upon this bill, which I hope we do, maybe we can figure out a way to talk to the judiciary and see if we can fix that issue, perhaps with this, unless the chairman already has another fix. Maybe we can talk about that later. But my question is about the opposition is going to say, if there is opposition to this, the opposition is going to say that kind of what Delegate Cox already said, that you have people who have essentially been, or I shouldn't say, you have people who are going to want to know that people had PBJs or null process or dismissals or lack of charging on their records, so they can use that because they believe that is valuable information. I happen to disagree, but I was wondering if you could react to that and say, why is it that we should have this stuff expunged if there was never a conviction in the first place?
Right. Thank you for that question, Delegate Carden. And I'll also lead to my panel after I answer that. My honest answer to you and to the committee and to the public is, we're always seeking justice. I could speak an hour on that question. We're always seeking what justice is and what does it look like and who is justice for and who is in the system in this committee. And I think for me with this bill is we have to find a line of where you're not always tainted by something and there's a break and there's a renewal and a rebirth and it's you move on from what you did, right? So when you have, we talk about it in the landlord tenant realm, with you keep getting filed for eviction, but you pay in time, and then it stays on your record. It's hard to buy a place, all of those things that drag on your record that aren't actual convictions, right? I think really puts you in a different place and a different setting than other Marylanders. And so for me, this bill is about really us, and in so many aspects of law that we talk about in this committee, and with all of the committee's wonderful ideas, figuring out when does the line actually stop and we let someone move forward with whatever incident, issue, and or conviction that they're dealing with. And when are we satisfied and okay with a constant tainting of someone, right? And that's why it's very serious. And I don't want to get the whole committee excited by me saying this next statement, but that's why I have real thoughts and that I've expressed in this committee about when we think about registries, right? because it's not that the crime ever ends, you're constantly on something. And having a slew of PBJs or stats, you're constantly on, it's not a registry, but it's like a light version of you might not be a fully 100% individual, right? That's what it's basically doing when you go and interact with the greater world and community. And I definitely think there are times where I have my elder abuse registry bill. We all kind of different things that there are registries I think are super appropriate and definitely we should have. But there are times where I think you have to eventually say, you're gonna start anew and go forth in society, and what it's done is done. And I think that's what sorry to be so like that. I don't even know what word that is, but sorry to be so philosophical about it. But that is really how I view the issue. And I know for Ms. Haven or Mr. Dews on my panel, they may have their practical perspective if they want to offer it. But I mean, that's basically my best answer I could give you as to what I would say to that. I think Mr. Dews wants. Okay.
I actually love to respond. Thank you, Delegate Fisher, but I've actually forgotten the question. So if Mr. Carter.
Oh, so sorry I talk so much. My bad.
So the question was, the opposition's going to say, look, we want to have all this information. We should know that somebody had a PBJ, that somebody is on a stat or had a stat. But if it winds up in a non-conviction, why should they have access to that information?
Yeah, well, I mean, the way I would answer that question is, once again, we have to look at the weight of these types of things. I cannot stress this enough, that there are 1,100 collateral consequences, according to the Collateral Consequences Resource Center. And these are non-convictions. So, I mean, from a legal perspective, and I am not nearly as much of a legal scholar as the beautiful people on this panel, but I would argue from a legal perspective, if it's considered a non-conviction, the idea that, well, we need to keep a track on this person, it kind of reeks of eliminating the presumption of innocence. And I think that's a huge issue. But for us at JOTF, as well as a variety of our other partners, it's more the fact that it's a barrier to other things. So I'm sure there's a lot of things that the judiciary is going to say to that, or state's attorney's office is going to say to that. But the moral of the story is these things should not be holding back individuals, especially when we have so many openings in the labor market, from having access to housing, education, occupational licensing, employment, and even business loans when they are non-convictions. I cannot stress this enough. As an employer, my father's been one, I've been in a position where you're hiring. It is very confusing if you are not a legal scholar when you see these things pop up on a person's record, and it's like 15 of them, and they're all non-convictions. It doesn't make any sense, especially since we have an issue, and different jurisdictions do it differently, of overcharging. So I would basically weigh the barriers that these non-convictions leave on a person's record against this kind of, where there's smoke, there's fire, elimination of presumption of innocence argument.
Thank you, Mr. Dews, for helping me with that.
Anytime, Delegate, you're the best.
Should I let Delegate Arakan ask questions before me or not?
Oh no, Mr. Chair, don't ask me.
Delegate Arakan for questions.
Thank you, Mr. Chair. In fact, Mr. Chair, maybe you'll be the best person to actually answer my question.
I'm not a witness in this.
I know, but you have such a wealth of knowledge.
Am I not enough, Delegate Arakan? Am I not enough?
I'm looking really for more of maybe the prosecutors will be up next. I
did prosecute.
Has somebody ever been like stat process for, I don't know, like carrying a firearm illegally? Is that something that you can get a stat for? Has that ever happened before?
I mean, technically, yes.
Okay,
so you're asking me if I don't know if you were.
Yeah, I just want to know if that's a thing. I mean, I was pretty sure it was, but I just wanted to confirm. And I see the chair is gently nodding, but trying not to answer because he's not.
Yeah, I mean, technically, when a prosecutor, and believe it or not, for my colleagues, I have been a prosecutor. When a prosecutor.
Oh, I forgot. Oh my God.
Yeah,
you sides, girl. Yeah, I forgot about that.
When you put something on the stat docket, right? It's at the pleasure. It's prosecutorial discretion, right? So you're offering that up, or Mr. Chair doesn't look at it that way. You're saying that you're gonna, and the person is willing to accept the stat, right? But they also have to be willing to accept that stat. So it's that crime, yes, can be definitely put on a stat.
Yeah. So here's my thing. The businesses my husband and I own operate off of the property where my children live, right? If I'm going to hire somebody to work for my business, and don't you think that I should have the right to know if the person I'm looking to hire has had some kind of gun crime on, maybe they weren't convicted, maybe it was a stat, maybe they had 1 or 2. Shouldn't that be something that a parent like me would have the right to know? So I can say, you know what, I have another great candidate who's equally as qualified, but hasn't had issues with gun crimes.
I'm gonna refer that to the experts on employment, as I'm not an employment expert. And so I'm going to go to
but you're a
Mr. Dews or
person
Mr.
and
Wright.
you have nieces and nephews, I believe.
I do have 2 nephews that are wonderful, that are also going to be over policed by, more than other people's children.
I pray
on
that
this
does
call,
not
but
happen.
I'll refer to my panel, because I don't, unlike you, Delegate Eric, and I look to you in that I don't run a business in the sense of I'm an attorney. I have a different, I don't do what you do every day, and your job and your family and all of that. So I really actually would refer to either Mr. Dews or Mr. Wright in that way, because I actually don't do that every day. So I'll refer them to answer that question.
I think Mr. Wright is going to have a lot to say about that, but I will say, Delegate Eric, and first of all, it's a beautiful question, and I thank you for that question. And I know that you also have a lot of experience, with firearms. So I just say that to say that, I just have to keep in mind, these are non-convictions. And I know from certain people in certain counties, people can get hit with firearm charges all the time. It's a non-conviction. So the idea of and of course, your business, you do whatever you please, you have the power there. But the idea of not hiring, this is exactly what we're talking about. The idea of not hiring somebody off of a charge that they were not found guilty of, you're like legitimately naming the barrier. And so the question really is, should that person have a black mark against them when they were not found guilty? I guess this is an ideological thing in JOTF's belief. If you were not found guilty, it was not a conviction, we don't believe that should be held against an individual with regards to employment, because they need to work. And once again, there's 1.5 million Marylanders who have some type of record. A lot of those have to do with non-convictions where they were not found guilty. So I'll pass it over to Mr. Wright, but that is a very interesting question, and I thank you for that, Delegate.
Yeah, maybe Mr. Wright has an opinion that differs, let's say.
Well, I appreciate everything that Chris was saying, and I don't think any of that is incorrect. But I think the most important response in relationship to your question is that no one's arguing for the expansion of expungement law. It's just not part of this bill, not part of the conversation. It is already in the books, straightforward process. If you have a PBJ, no subsequent convictions, you've made sure all of the terms are met, you can get it expunged. And what we're talking about here today is whether or not someone needs to have knowledge of that law, someone needs to have some engagement with an attorney perhaps in order to do that process. So it's really about who gets to access and who gets to have equal representation under the law as it's already written.
Okay,
what were you saying?
I was gonna say, so I'm looking at somebody, let's say we're looking at somebody who still has the stats, let's say there was 1 or 2 for gun-related infractions on their criminal record, and they, I'm trying to find somebody to hire, and they're now not even willing to go to actually take the steps to fix it when they could. Would you pick that candidate who's applying for a position over someone who maybe actually did go to get it expunged because they're responsible and they were willing to put the money down to step up and do that? That's who is the better candidate? If you had to choose between those 2 candidates for your job that you were trying to fill, who would you rather pick? I would pick the person that went and actually put their first foot forward and moved their butt to get the expungement, not had it automatically removed.
Yeah,
sure.
Sorry, go ahead, Jason.
I just a quick response, and I'll pass it off to Chris. What I would say is that, I don't think it's necessarily about personal responsibility or having the individual gumption to go out and do that filing. I think a lot of people don't know how the system works. As it stands right now, like the expungement law is more, I would say, significantly more complex than it was a few years ago. And unfortunately, and Chris could probably fill in on this, a lot of the communities that are being over-policed and are deeply affected by this don't have access to the same resources that I do or the same resources that you do. If I was involved in the criminal justice system in any way, because of my experiences, background, education, access to those resources, I'm going to do everything I can to get that expunged immediately. But even people who have had plenty of opportunities aren't always particularly well versed in arcane little corners of the law. If you've got access to a great attorney, another barrier right there. Maybe your attorney can fill you in with that information. Not everybody has that opportunity.
Yeah,
So
I'll just say I have a lot of friends who have gotten PBJs from all different walks of life, and all of them were able to get that stuff expunged because they wanted to get a job. They fought for it. They wanted it. And then those are the kind of people you want to hire, the ones that are willing to go out and figure out, what can I do to make myself a great candidate and how can I fix it? That's the kind of person you as a business owner, you want to hire that person, not the person that just is like, oh, I just don't know what to do here, and I'm not going to even try to figure it out. So thank you for answering my questions, though.
Yeah, I'll just say this really quickly. I'm all for people who have gumption and stick-to-itiveness, but I just want to hammer down on Jason's point. Once again, it's a non-conviction, but also that the issue is that many people do not know that they have it, or they don't really know the process. They assume, and I would assume this as well, that if I got picked up and they said, you look like some guy who did something, and then they released me 2 hours later, my philosophy would not be, oh yeah, I need to go get this. I would say, oh, it must be dropped because I didn't do anything. And so that I would, as Jason said, I don't think it's an aspect of responsibility. I think it's just an aspect of knowledge of something that you wouldn't necessarily know unless you're connected to people who already have that information. That's all I would say. But thank you, Delegate.
Waited long enough.
Are there questions for me, Mr. Chair?
I'll let you refer me to members of the panel as well if you want. I don't know that you need the help though.
Okay.
The first question is as to the date change on page 1 between effectively on line 17, 18. Why is it going back 3 years?
I think from what I understand, and my panel can correct me, I think that was thought of in order to match individuals with what we did last year and to encompass us, to get us to a place where, how do I say this? The crime, the automatic that was there would encompass people that would be included now with STET and PBJ. Does that am I making sense?
So in other words, it was to align it with the bill that we passed last year that had to do with the.
Yeah, so in theory, it's kind of like we made everyone whole at the same time, but of course, open to the committee on that, Mr. Chair.
Okay, let me go to the issue of stats. And so effectively there is, the state offers to place the matter on the stat docket with certain conditions, usually. Sometimes it can be it is obey all laws. It can be other things too, complete drug treatment, do community service, one of a million other things. But a case that's placed on the stat docket can be pulled off the stat docket at least after 3 years by one party or the other. Are you proposing that 3 years after the completion of the stat, it would be expunged automatically, or are you proposing immediately after the stat was finished?
I would be,
and furthermore, I mean, I guess that would mean that all stats would have to have included sort of obey all laws as sort of a throwaway item, because I guess it's not a throwaway item at all, but because you're requiring all court-ordered conditions to be satisfied.
Yeah, so I think in my mind, and I can't speak for everyone on my panel, on my mind, I would be happy with the clarification with the 3-year time period for stats. I think for a stat with obey all laws, I think if that's the only condition, the time, I think most prosecutors, in my view, you think about it as if you're obeying all laws for that time period. Before they have to want to bring it down or something like that. So that's kind of the everyday, at least my experience, notion of when a prosecutor gives you a stat with just that condition. So I would be open to clarifying it for that. I'm not sure on the other, I can't speak for my Senate cross file on the bill, but I would be open to that conversation, Mr. Chair.
So let me move now to probation before judgment and the interesting conversation that I'm sure to remember when we have another one of your bills in the future about how probation before judgment isn't a conviction. It is illegal. It was created, and I wasn't here when probation before judgment was created some time ago. But it basically was created so that it wouldn't be a conviction, so that you could come out the other side and say, I don't have a conviction on the backside of this, because the court looks at what happened and says, okay, usually this is a person who doesn't have a prior conviction. This is a person who has done what they need to do and perhaps in advance of a trial, and they've done what they needed to do with, okay, we're going to put you on probation and we're not going to let this count as a conviction. I don't disagree at all that it is not a conviction under the law. That is the magic of the probation before judgment. But there are some situations where it seems to me that a probation before judgment, where you might not want to do those things. For example, Delegate Fisher, would this apply to cases that were found to be domestically related? So in other words, those would be automatically expunged if somebody got a PBJ on a second degree assault and they completed domestic violence courses and so forth. They stayed away from the person, but that could be expunged from a person's record.
Yeah, so thanks, Mr. Chair. I'm trying to come to terms with this because I just amended my other bill with DV in mind. So I mentally have not brought those two concepts together. So I will have to get back to you and try to think my way through, unless someone on the
I'm
panel
not
wants
trying to be mean.
I know you're not. No,
it's very
it's very productive. I'm glad the public gets to see how you and I are. I thought that through with my other bill, and so now with this bill, I need to take that same thought. So I don't have an answer for you in this moment, but if someone else on my panel does,
that's fine. But let me give you more to chew on. And I'm not saying one way or the other, whether I think there are other issues that might have to be resolved here, but I also wonder whether this perhaps inadvertently creates a conflict of law in the sense that it's my, and I can go and look in the transportation article, but my impression is that you cannot expunge a driving under the influence charge. And I would suspect that would also include a probation before judgment for a driving under the influence charge. Does this bill allow someone to expunge automatically? Well, it wouldn't allow the person.
That wasn't my intent. That wasn't my intention to be that conflict.
I didn't suspect that.
It was not my intention to be that conflict, Mr. Chair. So I think I would need some clarifying language on things that are in the law that have already been set that it cannot be. I probably need an amendment to fix that conflict, Mr. Chair.
And I think that sort of goes to the broader question, and it doesn't. I don't know if it necessarily rules it out the bill out entirely at all. I just think there's a broader conversation that there are some areas of the law, and Delegate Arakan pointed out. I mean, to be frank, I have handled cases, and you can see them on case search, where the person received a probation before judgment, and they took a plea to the wearing and carrying of an unlawful firearm. They got a probation before judgment because they didn't have any prior record, because they admitted to it, they forfeited the firearm, and they went on their way. This is not. It is not just limited to those cases that are relatively minor in the grand scheme of things. It can be gun possession cases. It can be some other more serious cases. It could even theoretically be a felony that either gets stat or PBJ.
But I would add, Mr. Chair, that just to expand, and I totally understand that, and expanding on what Mr. Wright said, though, right now they could still get it expunged if they did the right steps to do it. So it's not like we're changing the fact that it wouldn't ever get expunged for when you give that PBJ. It's the fact that these would be included. Again, I probably need an amendment for the ones that are not expungible, just to make that clear in the law. Y'all know me, my bills never come in 100% perfect. I'd probably need an amendment. to
No
just
one's
fix that
bills
part.
come in 100% perfect. You're on the wrong committee for that.
I know, right?
Everybody's bills are wrong. They're all
Exactly.
wrong.
So I probably need an amendment
Terrible.
for that, but we're not changing the fact that the person that you gave that PBJ for, Mr. Chair, right now, without us doing anything, can still get it expunged upon their record, right? It's just it's an access issue. So I would say, and it's kind of like the comment I feel like I say throughout our committee, is that if you want this on someone's record forever, then you might need to go to the conviction route, because if it is a PBJ, or if it, or if it's like, if it's a PBJ, at the end of the day, the person get it off their record now, we're adding things that are under probation for judgment that are eligible for expungement and sets to be included on the access part. It's not whether they can be or not be. So that's what I would say in response to that, that issue and concern, Mr. Chair.
I'm going to be nice and not reflect on the fact that you think that I should get more convictions in cases. So we're going to leave you alone.
I think if you are in the seat as the prosecutor and you really feel that you want a conviction and you want this on this person's record forever, and you don't believe in that person's record ever being clean, then I say take it to trial. And I'm happy to say that to the public. When I would give out a PBJ or a stet, it's because I believed that person had a second chance. They had a clean record. I'm not stuck that it needs to be on their record forever. And that's, I really do believe that. And I'm happy to say that right here and right now.
So I'll quickly wrap up before giving it to Delegate Grammer and indulging myself a little bit here. And that, look, I see the broader point. I do see, and I see clearly. I think the distinction that happens sometimes in perhaps more serious cases is perhaps the state's attorney, who apparently is coming next, will want to take a look at what it kind of wants the person to file for that expungement to be able to take the next step forward. However, I do hear very clearly the comments, not just from Mr. Dews, but from others, that this is an access issue and a question of whether perhaps, not to pick on the public defender's office, but they've got enough going on as it is. It's hard for them to keep track of everything all at once. So in any case, we dealt with this issue last year, and we're back with it again, at least in part this year. So we'll do more about it. I see Delegate Grammer. I've spoken long enough. We'll go to Delegate Grammer, and then I think we'll hear from the state's attorneys. Delegate Grammer.
Thank you, Mr. Chair. So I have a question. So I represent a generally blue collar district, and I don't think people would be single-minded about, I think most people are subject to the misadventures of youth, and I think people would generally get the need to be able to move on and have career opportunities and so forth. My bigger concern is, or my bigger question is, when do our efforts fail to provide further opportunities and really become a detriment to people being able to employ folks that have some kind of record? And I'll give you a particular case that would be very relevant. There was a young man from my district who was shot. He was employed in the city working on a home. A guy named David Warren approached the home and got in a shootout. And the person from my district who was just there doing contracting work, he died in the crossfire. David Warren was public offender #1. I actually had my staff do a report on his record. He has 230 criminal counts, including 12 burglaries, 66 firearms violations, 24 robberies, and 24 counts of attempted murder. So if the principle here is that we expunge everything that's not a conviction, when are our records like a personal record, and when is it a public document? Because for me, I'm not an employer, but if I were, I would be open to hiring someone with a past. But if that person has a record of like assaults, I'm not going to put them in customer service. Or if a person has a record of like thefts, I'm not going to put them in inventory management, but I'd be open to finding them a position somewhere else. And I'm just, if this bill passes, someone like David Warren with 230 charges on his record, and this is an extreme case, granted, but it's not exclusive. I've looked at a lot of the offenders from crimes in my district who have extensive lists of charges. Some of those they were convicted for, some of those they were not. So when, I think there's a philosophical argument here, but I think there's also a practical argument for things that should remain on the record. And I wanted to see if maybe the panel could comment on that for me.
I'm curious, for that individual you brought up, were all of those charges, did they end in non-convictions or favorable dispositions?
Most of them, it's 230, and some of those are convictions, but most of those are non-convictions.
For the purposes of this bill, I don't think, this individual would necessarily be the kind of beneficiary we're talking about. I think we're also, I want to challenge the assumption that someone having a record is necessarily relevant to their qualifications for performance in the context of employment. I understand the reasons people look for that kind of information, but I don't think it speaks as closely to their character or their performance as people tend to believe.
And this isn't.
We're not talking about expanding expungement eligibility necessary to include things like attempted murder or any of those things. I think what we're talking about today with this bill is somewhat narrow in scope, actually. So if anyone else has any comments to offer on this.
Yeah, and I would say to you, Delegate Grimmer, thank you for your questions, and you're always insightful. I think the reality, even in your extreme case, anything that's on his record that is eligible for expungement today, and that was a non-conviction, your gentleman can, like I said before, can still do the paperwork and get those parts cleaned up on his record. This is just the access issue. So without us even talking about this bill today, your friend, the person you're talking about, can still go and clean up the non-convictions of PBJ, stat dismissals, whatever, if they did the paperwork to do that. This is an access of what is already expungible. So I think that's kind of what you have to weigh in your mind about it.
Okay, thank you.
And if I could just add, this bill also doesn't change the unit rule. So Delegate Grammer, in the situation that you gave, if all of these charges came from the same transaction and he was just charged with 240 some odd counts from the same activity, none of those are going to be expungible if there is a conviction in there that is not itself expungible. So, I appreciate the example, but I don't think it's really addressing what is the substance of this bill.
All right. We've asked them enough. Let's let them go.
Yeah, y'all gave me a hard time today.
Come on, it's easy going for this committee. All right, that concludes those people in favor of this legislation. We're going to hear from John Cox of the State's Attorneys Association, now in opposition, for 2 minutes. Is Mr. Cox in the room? John Cox? He's coming in here. Just one moment, please. All right, I see Mr. Cox. John Cox, if you'd like to go for 2 minutes, please, in opposition to the legislation.
Thank you, Chair Clippinger and members of the Judiciary Committee. I'm John Cox. I'm the Deputy State's Attorney in Baltimore County. I've been listening on the other side to all of the other testimony. I think it's important to emphasize, and every once in a while it comes up during this, that this is about basically just one issue. Right now, an individual with a probation before judgment, if they otherwise qualify, can get it expunged after 3 years, or a stet, and there is no otherwise qualify for that. They can get it expunged after 3 years. All they have to do is ask. All this bill does is make it automatic, which causes a number of significant problems. It says in the proposed bill that if the individual who got the PBJ or the stet has complied with all court-ordered conditions, and if they have been satisfied, but it's an automatic. Who makes and how is that determination made? Who's looking at it to see if the person has satisfied all those conditions? The state's attorney has been completely cut out of this. It's an automatic. We're not even allowed to weigh in those circumstances. It also completely ignores what this legislature has decided is a valid reason to not give somebody an expungement with regard particularly to PBJs. This legislature has decided under 10105 that you shouldn't be allowed to expunge a PBJ if you committed another crime within those 3 years after you got the PBJ and were convicted. So you shouldn't be allowed to expunge that. Here, it wouldn't matter. You could have been convicted of 10 different crimes after you got that PBJ. It's automatically going to be gone under this legislation. It was raised by the chair, I believe, that this would allow or would actually require the expungement of PBJ for a DUI automatically after 3 years. That clearly is not what the legislature intended. It cuts out the state's attorney completely. We should be allowed to weigh in on whether or not somebody is permitted legally to get an expungement, and that process is already in place. All the person has to do is ask, and then we will be able to look at it and see whether or not they're qualified for the expungement. We ask for an unfavorable report.
All right, thank you very much. Are there questions for Mr. Cox? Delegate McComas.
Thank you, Mr. Chair. Mr. Cox, I have a quick question. If this bill would pass in its present form, would it, do you think, cause a chilling effect for states' attorneys to grant PBJs instead if it was to be after 18 months automatically disappear?
Absolutely. I mean, when we face the reality that you know, the other example that I forgot to give was you can't get an expungement if you've got a pending charge when you're asking to expunge the PBJ, because obviously a judge is going to want to know if you get convicted of that. So the only avenue for us to avoid something happening bad as a result of that is to try to stop the PBJs from happening, stat less cases, get guilty findings so that a judge or the public can be properly advised of what this person has done. You're muted, Delegate.
Delegate McComas, you're muted.
Thank you, Mr. Chair. Just real quick, I was always under the impression, and I could be wrong, if a bill is expunged, whether it be a STED or a PBJ, and they're doing a pre-sentence investigation or the police need access to the person's criminal record, everything's expunged, right? So there's that record is not going to be available, that if they got like several DWIs and they're automatically expunged, or if there's automatic expunges of assault and batteries, there would not be any record of those. You know, when you're dealing with cases where there's some systemic problems with this individual, either they have a substance abuse or they have a history of violence or anger management issues. Can you answer that?
Yes, it would be gone. You cannot disclose if somebody somehow knew about it. If you disclosed it, you'd be committing a crime when you're looking in the section for disclosing an expunged matter. So yes, that would no longer be accessible.
So just to be correct, the judge wouldn't have it, and the prosecutor wouldn't have it, and the police wouldn't have it, and parole and probation wouldn't have it. It's just gone.
That's correct.
Okay, thank you.
Are there further questions for the panel? Thank you very much. That concludes the testimony on House Bill 122. And we will now go to our final bill of the afternoon, which is this one at the bottom, is House Bill 304, Delegate Ruth. I believe we heard this last year. However, staff have indicated it's new, so I will treat it as such. We will hear from Delegate Ruth, Evangeline Dawson, Munib Loraspi, Jeremy Lemaster, Gabriela Sevilla, Elizabeth Hilliard, Cassie O'Neill. Elizabeth Hilliard and Cassie O'Neill are both favorable with amendments. Then we'll hear from those people in opposition to the bill. So why don't we do this? We'll go through Delegate Ruth, Ms. Dawson, Munib Loraspi, Jeremy Lemaster, and Gabriela Sevilla. We'll hear from them and then we'll take questions. Then we'll hear from the two favorable with amendments. So Delegate Ruth for 3 minutes, please.
Thank you, Mr. Chair. And this bill is different than last year, and I'll get into that in a minute. Mr. Chair, Mr. Vice Chair, members of the committee, for the record, I'm Delegate Sheila Ruth presenting House Bill 304. This bill modifies the law, which makes it a crime to fail to obey a lawful order of a police officer. The failure to obey statute is vague, overly broad, and often abused by the police. Ways that failure to obey is misused include escalating a situation to provoke a response that will justify an arrest, creating probable cause to search an individual when no other crime has been committed and the Fourth Amendment would otherwise prohibit a search, arresting unhoused people who have committed no crime in order to remove them from a public area, and targeting Black, brown, and trans people who are viewed as suspicious because of an officer's explicit or implicit biases. Statewide, 63% of people charged with failure to obey were Black, including 53% where failure to obey was the sole charge. It's hard not to see implicit bias in these statistics. People with disabilities may also be unable to comply with orders from a police officer or even to understand the order due to a developmental disability, causing an escalation that could lead to arrest or even excessive force. And I know many of us were concerned about those videos that went viral from Ocean City this summer, 2 separate incidents a week apart. Because I've already been working on this failure to obey issue, it really jumped out at me that the failure to obey was a factor in both of those incidents. Several teens were charged with failure to obey. The earlier incident, Tazier Griffin, was an 18-year-old who was shot with a taser while his hands were up. He appeared to be trying to comply with the order to remove his backpack. A friend of his testified at the trial that there were so many commands going on at once. So I can imagine there was a lot of confusion about which orders he should obey. And, when he reached his hand back, it looked like to remove his backpack. That seemed to have, that likely triggered the response of shooting him with a taser, even though he was trying to comply with the order. For the incident a week later, the official statement from the Ocean City Police also shows how failure to obey plays a role in escalating these conflicts. So several of the people were charged with failure to obey. For one of them, the official statement says, officers observed Khalil Dwayne Warren, 19, standing on private property next to 2 no trespassing signs. Officers gave Warren a lawful order to leave the private property if he was not staying at the property. Warren became disorderly. Officers attempted to place Warren under arrest. Warren resisted arrest. Warren was charged with trespassing, posted property, interfere with arrest. So this seems to have been just a young man standing on the sidelines watching all this that was going on, and he probably didn't even notice the no trespassing signs. It didn't sound like he was, trying to cause any harm. I could see it as something that I might do, except that as a white middle-aged woman, I don't think anyone would question me for standing next to a no trespassing sign. And, particularly when it's
Delegate?
Yes, sir.
If
Yes,
you wrap
sir.
up. Thank you.
Thank you so much. Just really quickly, HB 304, the difference from last year is it limits the failure to obey law to only apply in emergency situations. That's based on some research over the interim. Or when necessary to protect an individual from a risk of imminent harm. Florida and Nevada both use this approach. And there are also 6 states that do not have lawful order statutes. It also removes incarceration as a penalty and creates tiered fines. So thank you so much. I apologize for running over my time, and I ask for a favorable report for HB 304.
All right, we'll hear now from Evangeline Dawson for 2 minutes, please.
Good afternoon, committee members. My name is Evangeline Dawson. I go by Angel, and I'm a paralegal at the Homeless Persons Representation Project, where I coordinate a pro bono criminal records expungement program that serves hundreds of individuals impacted by the criminal justice system in Maryland. So at HPRP, we know that Marylanders are all too often targeted with FOLO charges, failure to obey a lawful order. I'll just call it FOLO from now on, not because they pose a legitimate safety threat, but rather to remove them from public space and public sight. The overuse of FOLO charges is evident in the data from the Baltimore City District Court, which I believe a handful of us have submitted in our favorable testimony. So that data shows that 86.6 of FOLO charges are dropped in the Baltimore City District Court, which we might be familiar with what that means just from listening to the last expungement bill. So not guilty convictions. So for our clients at HPRP, the burden of a FOLO charge, whether it's dropped or not, does not end with the entry of the disposition. As we were talking about, or I was listening to y'all talk about with the last bill, FOLO charges, like all criminal charges, have the power to create and perpetuate homelessness in a number of ways. First, the disruption of an arrest for a charge that, again, 86.6% of the time shouldn't have happened, interrupts one's ability to go to work, to pay rent, to maintain professional and family relationships, to do all the things that prevent homelessness in the first place. Then, in the likely event that the charge is dropped, the charge will nonetheless continue to appear on any given individual's criminal record, publicly available to landlords and employers who may choose to not hire or offer a lease regardless of a non-guilty disposition. HPRP supports House Bill 304 because we are invested in eliminating unnecessary and harmful barriers to secure housing and employment. Further, we are invested in an end to the criminalization of homelessness and to an end of unnecessary police interactions with people who must live their private lives in public. Please join me in supporting House Bill 304 if you want to see Maryland respond to the data we have available on the overuse of FOLO in an ethical and moral manner with the conscientiousness of its impact on our unhoused communities in tow.
Thank you very much. We'll go now to Manib Lor-Osby. And I never pronounced his last name correctly, and I've met him multiple times, and I'm continuously embarrassed.
Thank you, Mr. Chair. You get better, a little bit better every year. So.
Well, you try. Okay.
So for the record, my name is Manib Lor-Osby. I'm an attorney with Disability Rights Maryland, here to express our strong support for House Bill 304. Our primary concern with the statute as it stands right now is its vagueness. What is a lawful order? When does failure to obey rise to a level that's actionable? Courts have been very deferential to the arresting officer in these situations. And as you can imagine, right, that's led to the racial disparities in arresting data that have already been talked about. And it has been submitted in our written testimony. I think it's worth repeating that 63% of people charged with FOLO between 2017 and 2019 were Black, whereas the Black population in Maryland was only 31%. So more than double the rate of the general population. As Delegate Ruth mentioned, folks with cognitive disabilities may not be able to understand an order in the first place in order to be able to comply with it. Folks with physical disabilities that may not be as visible, may not comply with the order to the satisfaction of the arresting officer. Again, remember, they have interpretive discretion. And finally, FOLO is a non-violent offense, right? If there are instances where someone is being violent, where the safety of his officers is threatened, of course, we want to make sure that's being protected. But there are other violent crimes that can be charged in those situations, right? If FOLO is the only thing that can be charged, we don't think it's appropriate to wrap someone up in the criminal justice system on that basis alone. So for all those reasons, Disability Rights Maryland encourages a favorable report from this committee on HB 304.
Thank you very much. Jeremy Lemaster for 2 minutes, please.
Thank you, Delegate Clippinger, and hello to the committee today. My name is Jeremy Lemaster. My pronouns are he and they, and I'm the Executive Director of Free State Justice, a statewide legal advocacy organization that seeks to improve the lives of low-income lesbian, gay, bisexual, transgender, and queer Marylanders. Historically, queerness, gender nonconformance, and cross-dressing in public have been heavily policed and surveilled, with concerted efforts to remove our community's right to exist publicly with dignity and respect. Today, that legacy continues with many of our members of our community, especially those that are Black and or trans, continuing to experience profiling and harassment from police officers. At Free State Justice, our second most common legal issue is criminal expungement services. Because of the constellation nuisance-related crimes our community is more vulnerable to. Upon a review of our own casework, of the 100 clients that we worked with on expungement services over the past 3 years, the majority of those services were for FOLO. To corroborate this experience, our 2016 needs assessment found that over a quarter of our community had negative police interactions to report. Most startling was that the majority of trans Marylanders, over 50%, would modify their daily routines to avoid any possible interactions with police. Community members report being harassed in their own neighborhoods for walking and even for being on their own property, and sort of just this sentiment of walking while trans. These experiences have been corroborated in the Department of Justice consent decree with the Baltimore Police Department, as well as additional national studies corroborating the enhanced scrutiny that our community experiences. These arrests sort of present significant barriers to employment and access to services. In a world where trans folks are disproportionately targeted for violence and hate, they often need to and look to the support of police officers to protect and serve, not to harass and assault. Police officers are not here to clean up the appearance of neighborhoods by removing individuals that don't fit in. LGBTQ Marylanders, especially trans Marylanders of color, deserve safe and affirming access to public spaces and public services. And that includes being able to trust our law enforcement to know the law and enforce it equitably with precision. Thank you.
Thank you. And now Gabriela Sevilla, please. For 2 minutes.
Thank you. Hello. My name is Gabriela Sevilla, and I'm a youth attorney at the National Homelessness Law Center, a Baltimore resident and a formerly homeless person myself. We are here in strong support of House Bill 304, which will limit the use of failure to obey a reasonable and lawful order to specific instances like emergencies. We support House Bill 304 because we need to enact change to prevent the further criminalization of people experiencing homelessness in Maryland. We believe that the current use of FOLO criminalizes homelessness in an ineffective manner and causes much more harm and costs the community much more money and does not address the real problem and the root causes of homelessness. These charges on unhoused folks, as you heard, create a criminal record that results in additional barriers to education, housing, and employment. With this new version of failure to obey a lawful order, our hope is the language will prevent FOLO from being used as a tool against unhoused Marylanders. This is, again, a human and civil rights issue. We should not punish someone for being without a home in a public space. It does not promote public safety. Current use of FOLO as written not only causes unnecessary trauma unhoused Marylanders, but also our youth, which you heard Delegate Ruth share the example that happened over the summer in Ocean City. And as a youth attorney, I must share this was a situation where youth were criminalized for being youth on the boardwalk of Maryland. And it seemed as though that FOLO, failure to obey a lawful order, actually escalated the situation in this one. We don't know, but this is just another situation in which we hope to avoid these unnecessary interactions with police. The National Homelessness Law Center strongly supports the steps being taken already by the Judiciary Committee, and we welcome the opportunity to continue working with the committee on the passage of HB 304 and on other legislation that would decriminalize homelessness and promote the safety of all Marylanders, regardless of their home status. Thank you.
Thank you very much. We'll now take questions for this first panel, and we'll go to Delegate Cox, then Delegate Shoemaker.
Thank you, Mr. Chair. Thank you, Delegate Ruth. I just real quickly, I think you did bring this bill, or someone brought this bill last year. One of the two quick things that stand out to me, first of all, I'm almost pushed to want to support parts of the bill after reading the sheriff's misguided position that they believe they can use this law to arrest people who don't wear masks. I think that was a complete misunderstanding of the intent of the law. But that aside, one of the things that reminds me of why this bill is very disturbing is the fact that you can, and correct me if I'm wrong, but right now it's not about homelessness or those without access to affordable housing. It's about whether someone has the right to camp out in front of your business. And I think last year the testimony indicated that if this bill were to pass, individuals could have multiple tents in front of right down a street, right on public sidewalks, and the police would no longer have the ability to ask them to move, which would obviously destroy both the access to the businesses and the commerce, as well as the health and safety of the community. So what's your thought about that?
Well, thank you. Oh, sorry. Thank you for the Thank you for the question, Delegate. There was a similar bill last session. The one last session was a complete repeal of the FOLO law, but based on feedback from this committee and research done on the interim, we came in with a new, more nuanced version that doesn't repeal it and instead limits it to certain situations, limits the financial impact and some other clarifying changes. In terms of your question about homelessness, first of all, if they are camped on business property, they are trespassing and the business can call the police to have them removed. But if they're on public property, it's public property and there's no reason to remove them. Now, homelessness is, it's a huge problem that we as a society have to find a resolution to. This bill is not going to do that. But until we do that, clearing homeless encampments is harmful to them. And I think Ms. Sevilla wanted to add something.
Thank you, Delegate Ruth. And to your question or a response to it, yes. So first about tents and encampments like that, I think Delegate Ruth was alluding to the CDC guidance against actually taking apart those camps right now during a pandemic due to actually public health risks. But aside from that, we have redone this bill in order to meet everyone's interests, business interests, but we also need to think about the interests of Marylanders who just may happen to not have a home, which could be me or you tomorrow if a fire happened or if we missed a paycheck. So that is the intent and what we believe we can still achieve the goals of promoting public safety while also protecting the civil and human rights of people who are unhoused.
So real quick, if there's an emergency, how would it not be simply the opportunity for the local officials to just declare an emergency under this bill and just do it anyway?
Well, thank you for that question. There is a specific definition of emergency in the bill. It says emergency means an urgent, sudden, and serious event or an unforeseen change in circumstances that necessitates immediate action to remedy harm or avert imminent danger to life or health. So if there's a fire and a police officer says, move now, I don't have time to explain, move now, and that's a lawful order, that's covered under emergency. But a homeless encampment, in no way could that be construed to necessitate immediate action to remedy harm or avert imminent danger to life or health.
Delegate Ruth, if the fire department was called to the homeless encampment because the fire at the encampment was out of control, would that be enough to constitute an emergency?
I think that would be.
Okay.
I think
Delegate Shoemaker.
Yeah, safe. Yes.
Okay. Delegate Shoemaker.
Thank you, Mr. Chairman. So Delegate Ruth, is the answer to Delegate Cox's question that under this iteration of the bill that's before us today, folks would be permitted to put up tents? Like I could put up a tent across the street from my office at the Jiffy Mart and camp out there, and police officers could not urge me to move along using the FOLO law?
Thank you for the question, Delegate. So a couple of things. First of all, the bill actually says nothing about whether you can or can't pitch a tent. It's not about that. It's about failure to obey a lawful order and what constitutes a lawful order, and the harm that can cause. If you're pitching a tent on the Jiffy Mart, you're on private property, and the Jiffy Mart can request that you be removed. And if you don't leave, you are trespassing. If you are not on the Jiffy Mart, if you're on public property, it is public property. Nothing prevents the police officer from, asking you to move, but no, you can't and shouldn't be arrested for the crime of not having a home. And yes, these are problems that we need to solve, but we're not going to solve them with this bill, and it takes a larger effort there.
I think last year when you came in with this, and I wasn't privileged to be on this committee last year, so I apologize for that. But I believe you were asked, I think by the chairman, if you had statistical information regarding the use of the FOLO law, like statewide. I heard a reference to Baltimore City. I'm just trying to get an idea as to the scope of the problem, or at least the problem that you perceive to exist statewide and using this law that you're seeking to modify.
So somebody want to answer that?
Yeah, if I may, Delegate Shoemaker. Between 2017 and 2019, we have our rates that I cited in my oral testimony, where 63% of folks charged with FOLO were Black. But we do have the underlying statistics for that I don't have handy, but can certainly forward to your office as soon as tomorrow.
I appreciate that. And one last question, Mr. Chairman, if I could. So, Delegate Ruth, let's say in a situation where you have a police officer, he's like making a Terry stop, I guess. He asks folks that he's stopped to take their hands out of their pocket out of concern for his safety or whatever the case may be. And if the suspect or the person who's being questioned fails to comply, this bill would take away the tool of officers to keep themselves safe by charging them with failure to obey a lawful order. Isn't that right?
Thank you.
Am I reading that correctly?
Thank you for the question. And as to the law, I'm going to see if any of the advocates can address that in terms of the law. But I will say that, these kinds of orders, this is the kind of situation where things can escalate very quickly and where it can be used in a very, discriminatory or abusive way, where I don't like your looks, so I'm going to order you to take your hands out of your pocket. There's no law that says you can't have your hands in your pocket. It seems like a very abusive power or potential for it. Now, I'm not saying that a police officer might not have a real concern, but that because of biases that we know that we have, it can be used in a way that is misuse. And I don't know if anybody wants to further address that in terms of the law.
I would just add in that I think reviewing the Department of Justice consent decree for Baltimore Police Department will clearly outline a lot of these questions here about the use of FOLO and specifically against communities of colors in Baltimore City.
And I'll just add to the question about trespassing or the question about an encampment on like a Jiffy Lube or any private business, and also to the question about hands in pockets. One issue that that comes up with failure to obey a lawful order is that it's a stand-in when no other criminal charges apply. In these situations, like if someone was trespassing, or let's say there was some other criminal charge going on with the person with the hands in their pockets, if they just have hands in their pockets, that's not a crime. But if they have hands in their pockets and they just mugged somebody, that is a crime. And so FOLO in these situations is unnecessary because there are other charges that actually pertain to whatever is going on that is actually criminal. But just asking somebody to leave a park because they're homeless, or asking someone to move off of a street corner because they're trans, that's not a crime. And that is where that's where myself and these other advocates take issue with the overuse of FOLO when no criminal charges actually apply. And we see that in data from the Baltimore City District Court about how much FOLO charges are overwhelmingly dropped, showing that there's nothing to substantiate them. They're just used to move people. And that's the issue. But when other criminal charges apply, like trespassing, or maybe the person with hands in their pockets just did something that merits another criminal charge, then there's a criminal charge for that.
And just as a reminder for, with this bill text, you'll notice that we still very much have, in the bill still containing that, prosecution, blocking of public conveyances, blocking of public places, persons, willfully obstructing free passages of others. Like those are still very much still there in the bill text, very so much are part of the law. Those things are not being removed. So all these examples that are sort of being raised here are actually not necessarily speaking to the modifications we're looking to add just to improve the use of failure to obey lawful order. We're not removing failure to obey lawful order. It's just ensuring that it's used in a very sort of informed and intentional way in the cases or events of emergency, and not used as it has evidence to as being used as sort of an arbitrary catch-all of being able to move people and remove them from public spaces.
Several more questions here. We'll move right along to Delegate Davis, please, then Delegate Erican, Delegate McComas.
Thank you, Mr. Chair. And thank you, Delegate Ruth, for bringing this legislation. I am always amazed at how we're okay that it disproportionately affects 63% of Black people and somehow there's nothing wrong with it. But my question is this. I know you presented this before the Legislative Black Caucus. And my first question is, what was the result there? And then secondly, someone just touched on the fact that FOLO is, first of all, it can be charged, there can be other charges associated with it, but I want to know how many times is it just FOLO charged?
Thank you so much for the question. I don't believe that we got a result from the Legislative Black Caucus yet. I asked my staff to check on that. And if I could pass the other question on to the advocates, is there somebody who can answer that?
I believe that should be in the same data set, Delegate Davis, that we're going to be forwarding to Delegate Shoemaker. So we'll make sure to include you on that.
We did have, hello. Yeah.
Please go ahead.
We did have data on Baltimore City specifically on when failure to obey a lawful order was charged alone, that Baltimore Action legal team put together and scraped where they could. There were limitations on access to records and things of that sort, but I'd be happy to forward it over to you after this. Thank you.
All right.
And Mr. Chair, if I could just really quick, I understand that the Legislative Black Caucus is supporting the bill. Thank you.
I did pull up, hi.
Thank you.
The data we did have on cases where at least one 86.6% of cases had all charges dropped when failure to obey a lawful order was charged. We also had from Baltimore City District Court had heard at least 13,437 cases that had at least one charge of failure to obey a lawful order. Out of all of these, over 85% of the total number of the cases got dropped entirely. Suggested an existence of over-policing. As someone may have mentioned before, and as we mentioned, the incident that happened in Ocean City, we believe FOLO as it's written is at times used in inappropriate situations. That is why we've written in this emergency definition with the Ocean City incident as well. We did see support from other House leadership on, supporting legislation that would help reduce the vagueness of FOLO, as it did cause harm to that youth there. And as we are testifying today, other Marylanders as well. So thank you.
Delegate Erican, please.
Thanks, Mr. Chair. So I just want to make sure I understand the difference between what the bill was last year and what it is this year. So I guess the goal is, so we can still move an encampment because there's other charges associated with that. Is that what we're saying? Because I know last year, testimony was heavily about not removing encampments from public property, but now I'm hearing today that there's other charges that are available to remove that. So that's not really a piece of it anymore. Is that right, Delegate Ruth?
Thank you for that question. And that's not really accurate. Our position is still that, encampments are not, if it's in a public place and it's not, blocking public access, that we should not be destroying those encampments. What was referred to is in the current statute, it does say a person may not willfully and without lawful purpose obstruct or hinder the free passage of another in a public place or on a public conveyance. So if you're obstructing so that people can't get through, that is still a crime. We're not taking that away.
Okay, so like you would just need, would it be like you could still be on either side of the sidewalk, but there would have to be an opening between the tents to get through to the front of the business? Is that
is
that what you're imagining?
I'm not a lawyer, and I think that would be up to the courts, but as long as you're not blocking a public, so that the public can't get through, then there's, there's no I mean, we shouldn't be destroying homeless encampments because.
So the only thing I'm imagining, so like, for example, my property goes to the road. And so there's no public property available in my neighborhood where people could do that. But there's a lot of communities that have sidewalks in front of their homes. And so those are owned by the municipality or the state or whatnot. So those people's homes could have encampments. People that live where I live, it would never happen to us because there is no property like that exists. Is that accurate?
I'm not quite sure I understand the question. To me, and I'm not a lawyer, but to me, logically, it seems like if you're blocking the sidewalk, that would be hindering the free passage of another. But I'm not a lawyer, so I have to leave that to the lawyers and to the courts to decide. But that is still there when people are blocking, when someone's blocking the passage.
Okay, so it should make it so that they can't go on sidewalks. It'd have to be like another place where other people don't travel, like state property or city property where people don't actually go.
Is there anyone in the advocates who could address that, or?
I think. Oh, go ahead, Gabby.
Great, thanks. I think from what we're getting at here, if there was a need to move people from a space because of an emergency, that still exists with this bill. This bill has nothing written into it about tents, encampments, or people experiencing homelessness. It's simply about reforming a law that police use. And to your question, if you're trying to make sure that people who own property are protected, right? If someone's in front of it, then they are. So there shouldn't be any concern about people blocking someone's passage to their home, because we need to enter and exit our homes, right, for emergencies of fire. So we should be good. And I hope this reaches the medium we want to see some change and to prevent some harm for when FOLO is not used correctly and when it's used not in emergencies.
Okay, so I think I'm getting a better picture of it, but I'm just imagining. So last time we were talking a lot about San Francisco, and what you would see was there would be like a business, and on the sidewalk, people would literally have set up. There would be a little walkway still, and people would have set up tents all along the sidewalks around the business. So the only way people could get in was to walk in that small space, but they still left a space so people could still move and they could still get to the business. But essentially the businesses are totally encompassed by tent cities and human feces and all sorts of other things. And I want to make sure I understand this bill will either yes or no allow that to occur in the state of Maryland.
To answer your question, Delegate Eric, and as long as there's free passage, yes, it would allow it.
Okay, that's fine. I just wanted to make sure I knew. Okay.
And if I may, Delegate Eric, and you mentioned that this wouldn't happen with your home, right? Because you do own private property out to the street, right? And I think you mentioned it yourself there, right? That there is an enforcement action available to you to the extent that you own private property, right? But anything that's not private property, right? A business could certainly buy land out to the street if they would like, right? But to the extent that they do not buy property, that property is not therefore private, and then there is therefore no private right of action on that property.
My worry was more people that live in cities and townhomes who also cannot buy their properties. They cannot buy the sidewalk in front of their home. It's not possible. So those people would not have any redress under the situation that you're proposing. Unlike me, I could just make them get off my property. Then they would be on the city street. That would also be illegal. So it wouldn't happen where I live. But there are people that live in communities with townhome situations and apartment buildings that come up to city property, those people could potentially have to walk outside every day and step over people living in tents on their property. I think that's what I wanted to make sure we either understood that it could not happen or it could under this bill. And I hear you that could happen as long as there was enough space they could walk around.
Well, it could not happen on private property, Delegate.
Correct,
So
but on the
again,
city
wanted to-
property, so, you know, the sidewalk is never owned by the townhome in front of it. It's always.
That's right.
So it could potentially happen like that. So I
and the
appreciate
folks
that.
experiencing
and I-
homelessness have just as much rights in that public space as the private property owners, again, because it's public.
Yeah, or the renters trying to get back into their home with their children, but I understand. Thank you.
Delegate McComas, please.
Thank you, Mr. Chair. I guess I have a little bit of a concern. You're saying that the folks that are homeless have a right to that property. Isn't it not true that a lot of the people that are homeless are not from the state of Maryland necessarily, or from the community that they want to camp out at?
Could I?
I'm sorry. Can we I have to say, I'm not sure that that's really directly on the bill. I think
Well,
that's
where I'm going with this.
Let's get to where you're going. Let's get to where you're going.
All right, just in fact, the folks in the city of Baltimore, as well as and the businesses, the people that live there that own property, they pay taxes. Same way with all the municipalities and in the counties where they live in communities. So I think that, you know, to say that, well, they, you know, everybody can have a, you know, pitch a tent on a public sidewalk. Well, that is going to change the whole community. It's going to change. I mean, isn't it so that it'll change the community? It'll change the business environment. It'll change the desirability of wanting to live there. Isn't that true?
Delegate, you mentioned taxpayers, and there's nothing that says that homeless people are not taxpayers, and some of them may be current taxpayers, or they may have become homeless due to loss of a job, loss of a house, loss of, you know, income, and have paid substantial amount of taxes before they had lost their income. So they may either be current or former taxpayers, and so they also contributed to that public property.
Can I add, just want to push back on some of the misinformation about homeless people that is being generated. Just want to say that I have hundreds of clients in my program in Baltimore City, and overwhelmingly all of them are from Baltimore City, and they're homeless folks. They're folks who are experiencing risk of homelessness, and that also, yes, many of them are employed and are taxpayers.
Okay.
I also just want to add in too that the use of this in Baltimore City specifically against communities of color has been disproportionately used against people who are not necessarily unhoused. And so this law is being applied to folks that are unhoused or that do have housing. For us at Free State Justice and for the trans clients that I was referring to, these are neighborhoods that they live in, that they walk around in houses that they live in, and in their own neighborhoods are being detained and removed from because their presence in public is seen as sort of undesired. People don't like to see trans people in their neighborhoods. And so it's not just, I think, some of the issues that you're getting to. I think this is really sort of applies to a whole swath of Marylanders as well. And so, you know, I know that there's a lot of sort of anti-homeless, kind of rhetoric and sentiment here, but do just want to make sure that this is something that really kind of broadly applies to a number of different communities. And again, we're not removing this as a tool from police officers. We're just improving the tool so that it's used with precision and sort of more deliberately in a way that it doesn't wildly sort of disproportionately impact these marginalized communities.
I just have a follow-up question. Okay, hypothetically, it probably is not a good idea for a homeless person to sleep in a park, okay, because overnight, because they could become a victim of crime. Is that fair to say?
Delegate, Madam Delegate, I kind of feel like we're getting off of the bill.
Well, but where I'm going, Delegate Ruth, where I'm going with this is the fact that if we say that the police officer can't say, you know, you need to move on, that basically he might be doing that to protect the safety if it's dark out. and let's say it's cold, and you want that person not to bunk out in a park where they could, become a victim of crime, okay, or they could die of hypothermia or something. So basically, you're kind of like, because the law of unintended consequences is going to create a chilling effect for that officer to go up to the homeless person and say, you need to move on. And basically he's doing it for the person's benefit. And I just don't see why just a whole blanket saying this is bad is necessarily going to bring the results you want. So if you can explain that it's going to be just this panacea to solve this problem, please enlighten me.
Thank you, Delegate. And it's not a panacea to solve any problems, but it is, an important thing to address this issue of the vague overuse of this tool. And the bill does allow it to be used in cases of necessary to protect an individual from objective risk of imminent harm. Now, I wouldn't say a vague, you might be mugged is imminent harm, but if it's well below freezing, that might be imminent harm. However, I would say that a better solution would be for a police officer to help that person find maybe a warming shelter or someplace that they could go to get out of the cold, because arresting a homeless person is now going to put that on their record, which makes it harder for them to find a job, which makes it then harder for them to get out of this unhoused situation.
Yes, and Delegate
Anderson, please, Delegate Anderson.
Next question.
Yeah, thank you very much, Mr. Chairman. Can you guys hear me?
Yes.
Okay. I'm a little confused, and I think probably part of the confusion may come from the fact that the part of the law that you want to change, the failure to obey a lawful order of a police officer, is in a section of the law that deals with people who are blocking public roadways and things like that. But there's never been, at least in my 25 to 30 years of practicing criminal law, the ability for a police officer to order somebody to do something that was not, the order had to be given with the intent of preventing a disturbance of the public peace. That is the only situation under which a police officer can actually give you an order. He can't order you to take your hands out of your pocket. He can't order you to move along unless it's dealing with the liquor store bills where people stand in front of liquor stores. But currently under the law, and if you read the law as it stands, a person may not willfully disobey the order of a police officer reasonably given to prevent the disturbance of the public peace. One of the young ladies who talked, I think it was Ms. Sevilla, who said that in Baltimore City, where there was only this charge given, a majority of the cases were dismissed. And it wasn't because, well, I can't say what the reasons were, but I can guarantee you many of these charges were dismissed because the officer hadn't given that type of an order. And a judge, who was the arbiter, decided that the order that you gave does not comply with the law, and therefore this person didn't break the law. So my question to you guys is this: what you're now asking for, you're creating a new law that gives officers the ability to give orders in addition to the one that's currently in the law. And I think that you're opening it up. Well, let me ask you directly. Do you not think that maybe you're giving police officers more ability to make these orders as opposed to the limited ability I think they have under current law?
Well, thank you for that question, Delegate. And the problem with the current law is that it is vague, and almost anything can be considered a disturbance of the public peace, or they can say that it was with the intent to cause a disturbance of the public peace. And so I think that's the real issue with it. We're not intending to create a new law. And we're just trying to define very specifically when those orders, disturbance of a public peace is so vague that it's not really specific. And if this committee would want to change it to a full repeal, I would certainly support that. I certainly not intending to create a new law. But, you know, and in terms of your point about charges being dropped, even just an arrest where the charges are dropped has an impact on a person. And so if police officers are overcharging this to the point that many of the times they're charging it are not valid, that's exactly the problem with this law, is that it is vague, and even the police officers don't understand when they can use it.
Okay, well, I appreciate your response, and I tend to think that the problem is not necessarily the law, as it is the training of the police officers, perhaps. That look, the chair and I have done, between the two of us, thousands of criminal cases. And I guarantee you, at least I can remember specifically about 10 or 12 cases where my client was charged with failing to obey the officer, failing to obey the reasonable command of an officer. And I argued to the judge, so Your Honor, there was nobody else on the street. There was no possibility of there being a disturbance of the public peace. And therefore the officer had no ability to give, this was not a lawful order given by the officer. And the judges have agreed. So it's not vague. I think the law is very specific. And my concern, though, again, I'll ask you again, by adding to the current law a definition now of lawful order means a command given at the scene of an emergency or necessary to protect an individual from objective risk of imminent harm. Again, those two kind of seem, at least if you think disturbance of the public peace is vague, I think these are at least as equally vague in terms of giving the officer the ability to have an order, to give an order.
Thank you, Delegate. And I certainly, like I said, I'm open to a full repeal if that's what this committee thinks is best. We did do a lot of research in the interim about lawful order statutes, and there are 6 states which do not even have a general lawful order statute. And there are some that limit it in scope to particular situations. 2 of those, Florida and Nevada, limit it to the scene of an emergency. And so we could envision a situation where, in an emergency, police orders need to be obeyed, quickly and often without question because there is an emergency. And so we thought that was a situation where we could be pretty clear about it. But again, as I say, if this committee thinks a full repeal is best, I'm open to it.
Thank you.
That concludes the questions to those people testifying solely in favor of the bill. Thank you all very much. We're now going to hear from Elizabeth Hilliard from the Office of the Public Defender and Cassie O'Neill. We'll hear from both of them. Each one of them will get 2 minutes, and then we will ask them questions. Then there are 3 people testifying in opposition. So as members of the committee now, we did for about an hour there on questions to the favorable panel, everybody. So, is this question really necessary? And did you ask it before? Should kind of pop through your mind. Love you all very much. All right, great. Elizabeth Hilliard, please, from the Office of the Public Defender, if we could.
Thank you, Chairman and delegates. I will try to heed your warning and also not repeat what we have already heard. We strongly, the
Let me
Maryland.
be clear, I'm not directing that towards the witnesses. You guys can say what you want to say.
I have been watching since 1. I've been
You're
here
fine.
along with you
That's
all,
fine.
so I'm just saying I get it.
All right. Thank
I'm
you.
the Assistant Director of Government Relations at the Maryland Office of the Public Defender. We strongly supported the full repeal last year. We would certainly support the same this year, as Delegate Ruth suggested. However, I'm here to propose 2 minor, or could be major based on the questions, amendments to how the bill has been introduced. Again, I don't want to reiterate too much of what everyone else has said, but the overbreadth and vagueness and the particular targeting of vulnerable, houseless, LGBT, and persons of color through the current statute is just unacceptable. And so we certainly think that there is an undeniable need for change, and we'd support the bill if it would be accepted this way only. But we would also recommend, and I'm going to try to drill this down pretty carefully. On page 3, line 4 of the bill, between CI3A and CI3B, we would love to see that or become an and, so that it would have to be an emergency situation and objective risk of imminent harm. And then we would also strongly urge the committee to consider changing this from a misdemeanor to a civil penalty or civil infraction with the fee scale that is already included. I believe you're going to hear next from someone from our office who has suffered the consequences of being convicted, definitely charged under the statute. And misdemeanors can completely fundamentally alter the course of someone's life. We would really, especially given the potential for misuse and abuse of this statute and of FOLOs, I did not know that's what they referred to until today, but we would strongly urge the committee to consider changing this from a misdemeanor to a civil penalty, civil infraction. Thank you very much for all your patience and hard work.
Thank you. All right, we'll now hear from Cassie O'Neill, please, for 2 minutes.
Sure. Good afternoon, Mr. Chair and members of the committee. My name is Casey O'Neill, and I'm here to share my story of being charged with this offense because I want you to understand why the law needs to change. I had the best case scenario. I had every advantage, and I didn't have a jail sentence from this charge. But even so, having to navigate the legal system for this obscure charge took years to fully resolve. Back in 2008, I was a college student at the University of Maryland. One night I went out to celebrate a friend's 21st birthday at the Thirsty Turtle. And at some point I left the bar to get some air, but when I tried to return, a police officer stopped me and told me to leave. He didn't give a reason, so I argued with him and explained that my belongings were still upstairs with my friends. I even tried to show him my ID in case he thought I was underage. Suddenly I was handcuffed, dragged past a line of onlookers to a police car and charged with disorderly conduct and failure to obey a reasonable and lawful order. I'm sure I did have too much to drink, but there was no warning and no emergency, and I didn't expect to go to jail for talking back. Being arrested this way was scary. It was humiliating. I was put in tight handcuffs that bruised my wrists, and my ankles were shackled and chained to a bench. My friends were extremely worried when I didn't make it home that night, and my brother had to drive from another county to pick me up from jail. My phone was lost in police custody for over a month, and then while I awaited trial, I knew I could be facing the possibility of a jail sentence, and I worried that having a criminal record could prevent me from becoming a social worker, which was my dream job. So I'm here speaking on my own behalf today, but I think it's worth noting that I am a social worker now and I work at the public defender's office. So I know exactly how lucky I was compared to most Marylanders who find themselves charged with a misdemeanor. I was a white college student whose parents were able to take off multiple days of work to help me find a lawyer, show up to court, enroll in community service. And those court costs didn't keep me from putting food on the table. I didn't have to navigate common stressors like childcare or unstable housing. Several years after this arrest, this charge came up on my background check because I didn't realize it was still on my record. But my employer was luckily sympathetic and I got to keep that job. So I figured out how to pay and apply for an expungement after that and went to grad school and became a social worker. So this charge is often no clear benefit to public safety, but with significant collateral consequences. And for me, it was a major inconvenience.
Ms. O'Neill.
With fewer resources, it could have devastating impacts, and that's why I urge a favorable report with the amendments.
Thank you very much. Are there questions for this panel? Seeing none, we do thank you both very much for testifying today.
Thank you.
Thank you very much. We'll now hear from the opponents, Steve Kroll, Joe Riley, and Vince McAvoy. Each one of them will get 2 minutes. They're being led into the room right now. Mr. Kroll is in the room, the Zoom room. We'll start with you, Mr. Kroll, for 2 minutes.
Good afternoon, Mr. Chairman, members of the committee. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland and Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting crimes since 1984. And to tell Delegate Anderson, I've prosecuted many disorderly conduct, failure to obey cases just as senior in court with me when those have happened. I'm going to address a couple things. Number one, the statistics. We really can't get a good judge of statistics because of justice reinvestment and the Baltimore City consent decree. We really have to look at 2019, 2020 statistics and not before 2018 to get a real idea of how many citations have been issued. And I say citations because I want to see how many people have been arrested and how many people have given citations for this crime. I spoke to you last year when the proponents offered to repeal this bill and said that when officers arrive on the scene, especially when it comes to masking, and I was the one, Delegate Cox, who argued for masking, that an officer has no choice. It's the only tool in their toolbox to deal with masking. And this bill has to stay the way it is because it has no emphasis on the protecting police and protecting the public. If the word gets out, it's only a $100 fine. No one will respect police officers at all. No one at all. And they'll just say it's a $100 fine. I'll go and pay it. It's a civil citation. They'll say I'll go pay it from there. This bill has to say the same, and we're asking for an unfavorable report. I would only point out several things in conclusion. Number one is it is not vague. It's been on the books for years. I would like to see the statistics, as I said, and I'll be happy to talk to Delegate Ruth and the proponents in the future about bettering laws in Maryland. Thank you very much.
Thank you. Joe Riley, please, 2 minutes.
Thank you, Chair Clevenger. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. We seek an unfavorable report on House Bill 304. The current state of the law, it does allow for officers to be able to protect themselves in the community. What this bill would do would change that and sit it on its head. If this bill would pass, imagine the common everyday traffic stop. Certainly on the public roads of public conveyance, if the officer came down to a car and said, roll down your window, I need to talk to you, I need your license and registration, and that driver refused to roll down his window, this wouldn't be an emergency. There wouldn't be an imminent harm. What possible avenue would the officer have to get a compliance? If this law would pass, I don't know of any. And then there was talk about the Terry stop, a very common police interaction, a Terry frisk. There isn't a Terry frisk because someone doesn't like how a person looks, as was stated. There is a Terry frisk because an officer can reasonably and articulately say what they suspect the person of being armed. So it's not in an emergency situation. And I fear for the day that comes when officers aren't able to get somebody to take their hands out of their pockets, and they're going to be afraid that the person's armed, and then what consequences happen? Is that person shot? Is that person tased? God, I hope not. But if this law passes, that might be the outcome. This law passed, if this bill passes, you're going to see more harms caused than what they seek to rectify, and we seek an unfavorable report.
Vince McAvoy for 2 minutes, please. Mr. McAvoy.
All right, thank you so much, Chair. I hope that you all can hear me pretty good. This bill was brought last year, and I honestly hope that you all this has been a huge waste of time. Obeying lawful orders reduces harm to those that were brought up in this bill. And I didn't even see this bill going in this direction, but it's all over the place. For instance, the homeless get inside. The officer directs them inside. For someone with hands in their pockets, no violence because they're not looked at as a threat. For trans, to encourage them to walk away from homes and schools, not get arrested for prostitution. For me, last year, city sergeant asked me to get off the curb as Biden's procession was coming up to center stage a few months ago. And you know what? I got off the curb and onto the sidewalk. The sponsor makes baseless claims that it's not needed and that these things are criminal that's going on. This bias has to stop. Where do these people get off thinking that every police person is a criminal? They enforce the lawless activity. Okay, so I just think it's ironic since her district lies right along the city line, and we're experiencing year after year of record crime levels. This is not a time for this kind of bill. It just doesn't seem like she's been on a ride along with the police union. And the same goes for the other proponents of this bill. They want their select core people in America to not be arrested regardless of their culpability for criminal activity or reasonable suspicion. Honestly, these folks need to look up that word, suspicion. Police don't have magic minds, so they can see what everyone's carrying and what their intents are. They have to get on the scene and do the best that they can. And to that effort, I got an email I'm sending you all right now from last year's testimony showing you where people who did not obey the commands, the lawful commands, what happened to the police. And I don't think there hasn't been any concern for what's going on to these police as these people disobey orders. So you know what'll stop this? Quit having law clinics by football players and other non-lawyer activists telling people they don't have to obey the law. Obeying lawful order is not just a Simon Says issue. They're looking out for people. And I appreciate you all listening to the testimony.
Thank you very much.
You're welcome.
Questions for this panel? Delegate Anderson, please.
Yeah, I wanted to ask Mr. Riley about two of the examples that he gave. First, if a police officer pulls somebody over and the person refuses to roll down the window, what happens next?
Well, it would be a lawful order to do that. And then you
why would that be a lawful? How is that a lawful order?
To show me your license, roll down your window to show me your license and registration, I think is what I said.
But it wouldn't be a lawful order according to under this particular bill. This bill says that a person, I'm sorry.
Under this particular bill, it would not be a lawful order.
Correct.
This bill
Okay.
is fine.
Right. In other words, this bill deals only with giving a lawful order reasonably given to prevent the disturbance of a public peace. Is that correct?
Under this bill, it has to be an emergency. And
no, I'm sorry. Excuse me, not the bill, the law. The law as it currently exists.
Mm-hmm.
Police officer gives a reasonable order to prevent the disturbance of a public peace. That has to be obeyed, right?
Yeah. Yes.
But the order to take your hands out of your pocket, why does that have to be obeyed?
Well, if there's reasonable articulable suspicion that I'm going to conduct a Terry frisk of you because I have reasonable articulable suspicion that you might be armed. I need you to take your hands out of your pockets.
Okay, and if the defendant or the individual does not take his hands out of the pocket, what do you instruct your police officers to do?
Well, at that time, they could charge that person with failure to obey a lawful order if they don't do that. If they have reasonable articulable suspicion that a person is armed, I would hope that they would frisk that person.
Okay, that doesn't but it doesn't give you the ability or the officer the ability to arrest the person if he doesn't take his hands out of his pocket, but for your claim that he could do it under the current law to prevent disturbance of a public peace.
If he fails to do that and the officer comes to frisk him and then there's some sort of walking away, failing to do that, that would be, depending on the situation of it being in a public place, if it's on, I'm thinking like on a sidewalk, on a roadway, conveyances and such, not in a private locale.
Well, if the individual walks away, he can walk away, right?
In certain situations, you can walk away. If there is,
if on the situation you just mentioned,
you can walk away from the costume. You can't walk away from a Terry frisk because a Terry frisk, first there's a Terry stop, and you can't walk away from a Terry stop.
So you're under arrest?
No, you are investigatively stopped.
All right. So the police officer has a reasonable, articulable suspicion that you may be carrying a gun or you have drugs, right? And under that scenario, you're saying that the officer can search the person, correct?
Conduct a Terry frisk, which is
frisk. But it doesn't have anything to do with him ordering him to take his hands out of his pocket.
Well, to take a frisk, I would have to pat you down, and if your hands are in your pockets, I can't really feel what's in your pockets.
Okay. So basically what you're saying, regardless of whether this bill, this law stands or exists, that officer can still order the person to take his hands out of his pocket. That officer can still make the driver give up his driver's license because neither one of those situations has anything to do with the prevention of a disturbance of the public peace.
Well, let's see. If there has to be the public peace. I mean, if you're just looking at a blanket, okay, it's two persons, an individual and an officer, then yeah, you're probably right. But if there's a situation where there is the public around, let's say you're at Raven Stadium or some sort of thing like that, and there's some sort of reasonable articulable suspicion that this person's coming in armed with a knife into the stadium, then you would have the ability to reasonably ask that person, you order them to stop, and then you would conduct the pat down. Now, if this law passes and that person refuses to do that, the officer has no remedy if you refuse to do that.
Okay, well, I think you just kind of like countermanded your own argument that the officer has the ability in a Terry situation to search a person.
To frisk a person, but if they
frisk a
refuse,
person, and if a person walks away, then the officer's reasonable articulable suspicion is heightened where he could arrest the person.
yes, he could.
Right.
If this bill passes, he could not.
I think he still could.
Well, there wouldn't be an emergency. Where would the emergency be? This law defines
The facts that you just stated, that the officer has a reasonable articulable suspicion that this person is armed, and therefore the officer is going to conduct a Terry stop. This bill has nothing to do with that.
I think this bill defines emergency very narrowly, and it as an urgent, sudden, and serious event or unforeseen change in circumstances that necessitates immediate action or remedy, and that scenario wouldn't exist on the common Terry stop.
All right, well,
that's my opinion. I mean, I could be wrong.
Okay, one last question, Mr. Kroll, Mr. Chairman, please. All right, thanks.
Okay.
Mr. Kroll, you mentioned the fact you and I have been in court a lot against each other.
Yes.
And I know you've had many cases where a judge has granted, found a person guilty of violating the current law with regard to a reasonable order, an order reasonably given. And I think you've probably seen a judge find a person not guilty for that same reason. Could you give me, if you can, and I'm not saying you have to, but a percentage in your own opinion of cases that you've seen or you've participated in where the person was found guilty, person was found not guilty?
Delegate Anderson, I cannot give you a percentage, but I can say is the cases that I've had, the failure to obey a lawful order of a police officer accompanies other charges. It usually does not stand alone.
Right.
In the cases that I've had, that I can tell you from my own experience. Other than that, I can't give you a percentage of guilt or not guilt.
Right.
I'm sorry.
And one possible scenario would be the officer is attempting to make a lawful arrest of a person in front of 4 or 5 or 6 other people. And the officer may be afraid that a crowd will gather, that there will be a disturbance of the public peace. And he gives an order to, or his partner gives an order to one of the people in the crowd to move back onto the sidewalk. That's an order reasonably given to prevent a disturbance of the public peace. I get that. And usually it's with, as you say, other charges. But as a standalone order, officer cannot order you. He can't get out of his car and say, without any reason, Stephen Kroll, get out of your car. I want to see your hands.
What I've seen, Delegate Anderson, is officers, especially in the past 2 years, do everything they can not to arrest someone. They beg people, I don't want to arrest you. I don't want to arrest you. And at the last moment, because the person's not listening and failed to obey a lawful police order, they get arrested. That's what I've seen in the past 2 years. That I can tell you.
All right, well,
but they're begging people not to be arrested, or in the case of JRA, not to be issued a summons, a paper summons.
Yeah, I can't argue with that fact. But thank you so much, Mr. Riley and Mr. Kroll, for your answers. Appreciate it.
There are no other questions for those in opposition, and we thank you all for testifying here today. That concludes the testimony on House Bill 304. We appreciate everyone coming and speaking to us on that bill and all the bills today. That does conclude the testimony and today's bill hearings in the House Judiciary Committee. We will be back tomorrow at 1 o'clock, and we'll see everyone